May with the Lordship's kind permission, you mentioned that the review petition of 2020, the quorum was Justice B.R. Sarangi and Justice S.K. Pani. Now, my lord, the urgency is now the demand which has been upheld.
Give your script.
Pardon to make a mention. Lord, a bail application in a criminal appeal 227 of 2023 that was rejected by a division bench of my Lord Justice D. Das and Justice S.K. Pandey. I have filed another bail application because he is seriously ill. Can that bench be constituted on Friday?
That will be constituted the moment your slip reaches the deputy registrar.
So I have made mentions. The deputy registrar says that it has to be mentioned before.
No, deputy registrar cannot say.
You were the old one. Before whom did you mention?
Not before the old one.
He
Pardon,
cannot say.
pardon
He
to-
could not have said.
Pardon to
So
mention
that
my,
was standing instruction.
Lordship listing for
pardon to mention my lordship. Your lordship is matter related with mines and minerals. Mines and minerals case, your lordship. Here, your lordship, petitioner was stood as L1 and this bid was conducted in the year 2022.
You
But-
are L1.
L1, your lordship. But the sport,
L1 how? L1 in mine.
level 1, stood first and I got the bid.
H1.
L1, your lordship.
You are H1.
My lord,
Because lowest bid will not be
lowest
accepted.
bidder.
Highest
I
will
am
be
the,
accepted.
I am the lowest bidder, your lordship. I
Then
have
the-
selected for the operative stone quarry in the year 2022.
Yeah.
Here, your lordship,
Rather than how
yes, your lordship.
L1 will not
Till
be given.
22 to 24, your lordship, the sport was not identified with opposite party number 3.
All right, what do you want?
My lord, now the demand notice was issued by the opposite party number 3.
What
The
has been issued?
demand notice in the year 2024, when I am going to operate the stone quarry, your lordship. I have not operated since last 2 years, but demand notice was issued against me. This is
When was the
urgent,
notice issued?
my lord.
When was the demand notice sent?
In the year 24, April 24, your lordship. I got so many, I filed so many representation, but it was not considered.
Presentation will not do. Give your slip. Give your slips, I'll see.
My lord.
Pardon to mention, my lords. Item number 36, my lords. That's the respondent, my lord, Mr. Mahapatra's, my lords, brother expert. Today is the 10th day. I have taken consent of the appellant, my lords. May I pray on Monday, my lords, next Monday, on 15th.
Item 32. 32, may I pray for 10 days after. I have
Let the matter
taken
be
consent,
called. Let the matter be called.
taken consent from.
Let the matter be called.
Lordship listed for contempt 12 July. Listed for contempt 12 July. Government advocate told to me after Monday you will say to Lordship suspension allowance is not complied.
Yes, please for the state.
My lordship, before. My lord, the earlier bail application was filed and was rejected by.
No, no. Subsistence allowance. You are not getting subsistence allowance. Please give your, which department is this?
Revenue.
Revenue.
Hmm.
How subsistence allowance can be?
No, sir. I don't know why it's in my.
Give your slip. to him.
Last week she had mentioned we have got the records notes. I have asked to the officers, but she has been anxious notes. I said that wait for a week. So
Please
material
wait.
listed. So
Please wait.
Mr.
Come next week.
Lordship, anemia patient, she is a innocent bride, unmarried anemia
Come next
patient.
week. Next week you will come to tell us that everything has been paid.
But she mentioned the lawsuit directed us. We have already intimated the officer to get it done
Subsistence
immediately.
allowance cannot be withheld.
Next week we will see that it is done, my lord. And it is, I know it's anxiety, my lord. His own sister, so I had assured that I will see that it is done.
Don't worry.
Pardon to mention from the list, your lordship, item number 31. Lordship, as it is an old matter, we don't have the record and it is not paginated well.
Let the matter be called first.
Obliged.
My lord, I may pardon, out of list, man. Oh, writ appeal fresh matter, man.
Writ appeal will unlisted. You are not required to make a mention.
Number 76.
I'm sorry, my lord. Item 36. I am mentioned on. Let's take it.
It is mentioned good, sir.
Let the matter be called out. He, in fact, yes.
Interim order is taken. Yes,
What is it called?
okay.
So bereavement and family of Mr. Mahapatra.
Taken the consent.
To be mentioned, item number 1.
I beg pardon. In this case, my lord, paper book. I have not received paper late. I have not received the paper book. So that can you
Paper ready and
Already had two
ready?
sets of.
Can you take it for next Monday or any day of your lordship's desires? Next Monday.
okay. Go ahead. How much time will you take?
Then it will take, my lord, within 1 hour, within half an hour, it will complete it.
How many witnesses are there?
There are 18 witnesses there.
Ah.
That eyewitness is 1, 2, 3. One is, there is no evidence. 2 and 3. 3 is doubtful. There's, and so far as 2 is concerned, that I have to, has not seen the occurrence.
And what is the offense?
My lord,
Offense.
offense 302.
Oh, that lady you have assaulted.
Lady is not
lady.
idle because the daughter has said she has not present at the time of it.
All right. No, it is that case. So you're supposed to be having some relationship with her.
Yes,
You have to
section
text her.
6 of the Evidence Act.
Yes.
So how much time?
No, but I will collect him lot today itself.
No, we are asking how much time will you take? So accordingly, we'll fix the time.
I am lost. I can within 22 to half an hour because only evidence I can appreciate the
So
loss.
we can fix it at 3:30.
Yes.
Yes. 3:30.
3:30 on next Monday.
My lord.
All right.
Yes.
Please give us the, if you can.
Date.
Date chart and plus.
Note of submission. FIR English translation.
My lord.
Depositions will be in English,
Yes.
but any other document which you wish to rely on, especially the FIR,
Yes.
please give English translation
My
with
lord.
advance copy to Mr. Samantray so that he can also check.
My lord.
All right.
Item number 2.
May I please? But the contempt application arising out of alleging the violation of interim order passed in writ appeal. And your lordship, writ appeal is filed against an interim order passed by the honorable single judge. So may I pray, my lordship may take up that writ appeal so that
Yes.
in writ appeal, both the appeals are identical. Annexure 4 at page 68 is under challenge. The relevant page,
You are for whom?
I am for the appellant.
No, the other side. Someone is appealing.
Yes.
Yes.
My lord.
You are appealing.
Relevant page at page 70.
Annexure 4.
Annexure 4.
The interim order.
Oh.
Yes.
The interim order is under challenge. An interim order is under challenge.
Yes.
What is that?
Interim order. I'll okay, lordship, paragraph 8.
Paragraph 8.
Yes. Before that, my lord, paragraph 7. May I read, my lord, however, stand has been taken in the said objection that the petitioner is not continued as a daily wager from the month of August 2020 till date, and as such, his claim for release of wages till date from August 2020 is baseless. though no reply to the said objection has been filed by the petitioner. Mr. Mishra, Learned Counsel for the petitioner, draws attention of this court to the averments made in paragraph 4 of the IA and submits that the specific averments made by the petitioner have not been disputed or denied by the contesting opposite parties. That paragraph has been quoted. That though the petitioner is continuing in service on DLR basis against vacant post by order of this honorable court, the opposite party number 3 and 4 have not released the wages from August 2020. So specific reply has been submitted. Since August 2020, the petitioner is not in duty. And that he has not replied. So because of the interim order passed in the writ petition, this honorable court in paragraph 8 has held that the petitioner is continuing, so he is liable to be receive the wages till the disposal of the writ petition.
Like,
Paragraph 8.
Writ petition?
And the writ petition has been filed challenging the abolition of post declared by the government. That is under challenge. That is under Annexure 12 at page.
petition আসছে না?
Why?
আছে? No, the list doesn't show it is here.
Whether there is any interim order in this case or not?
Yes, ma'am. In the writ appeal.
Huh?
Yes, ma'am. The writ appeal, your lordship find the order dated 27/9.
With appeal the ampakech, it's here. You wanted the writ petition to see what are the.
I have filed the interim order in contempt petition. Copy of the interim order.
What is
asked
the
in writ-
27?
What was your prayer?
My lord, in writ petition, my lord. Because, my lord, the government decided, issued a notification, my lord, in the August 2019 for information to upload the annual establishment review in
What
HRA.
was your relief in the writ petition?
Writ petition, my lord, since I was continuing 1992 on DLR basis against a vacant post, the post should not be abolished, my lord. And in fact, there is no order for abolish. There is a proposal to abolish.
Then we can get that.
And my lord, the honorable single judge, as an interim order, directed.
No, we will decide everything, your writ petition, writ appeal and contempt, all.
Yes.
All right. List these matters along with WPC number, so it's on 1 week. You have filed your affidavit, counter affidavit.
Yes. My lord, in WPC, my lord, just last week, they served me a counter, my lord.
Therefore, 1 week after, it will come after
My
1
lord,
week.
further 1 week, I will file rejoinder.
2 weeks, all right. They are enjoying the order, interim order.
No, my lord, interim order is to release their salary.
No, whether the interim order has been,
Passed to release my salary, regular
whether
salary,
in writ appeal, any order has been passed or not.
to pay the salary.
27/9/2000.
So therefore,
No, my lord, your lordship may kindly pay you that order. Last day, the respondent
Yes,
number.
that order will continue.
But they are not paying me, they pay me salary up to 15th May 2020, remaining the intervening period. Thereafter, they are not paying me.
where is the order?
The order dated 27/9, my lord.
In the contempt application, Annexure 1, your lordship.
What is this IA? You have filed an IA or he has filed?
For
I am not.
modification of
You have
that.
filed a IA.
Yes, yes.
You don't want to press that IA?
No, but, what happened? The challenging that abolition of post. Suppose in case the writ petitioner fails, how to recover that amount? He is not to any not in duty.
I'm
What
working.
we have paid. So lordship may hold that amount. I will deposit in registry. If he is entitled to, he can get.
I'm continuing since
But daily wage
1992.
basis he was continuing.
In IA, my lord, there is your last But the respondent.
That
number
I
was
have filed for modification. Lordship kindly see the order dated 27/9. The last.
1 week time, otherwise we will stay the entire order.
Two weeks time.
2 weeks time, but we are staying you will not get anything.
1 week or let.
Huh?
Or let 1 week.
1 week. 1 week interim order.
Test admission item number 3.
Today, my lord, upon the request of the learned AGA, my lords, on 21/5/2024, the learned AGA has requested to take time for getting inspection.
Whether order has been complied with or not.
Yes, my lord. That
Complied
has
with.
not been complied.
In fact, no, so, please to, adjourn it to today. Because the original file, I could not be also get it from the, though I will to reconstitute a file. It's only I pray because it's a 2018 matter. I had written a letter also, Lords may take it off.
This is 2017.
Yes, Lords.
We will not adjourn it. We'll take it up at 2 p.m. We'll take up the matter at 2 p.m.
Lords.
2 p.m.
Right.
And if
Item-
the order has not been complied with, then ask the land acquisition officer Jagat Singhpur.
Dr. Simpur,
He will join online.
Yeah.
Will frame charge, initiate proceeding.
Item number 4.
Maybe they could come other day.
Why?
Could not do the homework tomorrow, yesterday. I was out of Cuttack.
As requested, let's discuss on Monday.
Copy has not been served.
I shall solve the copy by
Copy
tomorrow.
has not been served. Your lordship may direct him to serve the.
By tomorrow.
Serve him.
Item number 5.
Taking time from the very beginning.
First of all, the Lordship had condoned the delay on 19/6/2024. The the issue, my lord, with respect to recruitment to the post of recruitment to the post of Sikhya Sahib. But the advertisement was issued in 2011. Now, this said advertisement was issued basing on a government resolution that is at page.
No, where is the order of this court?
Order of the Honorable Court, my lord, that is at page 15, Annexure 1. The petitioner applied for 2 education district and filed a affidavit, a false affidavit before the authorities, which was later detected that he had applied for 2 education district. He was issued with a show cause. He accepted that he had applied for 2 education district, and accordingly he was terminated from service. That was the subject matter of challenge before the land tribe before this honorable court in the writ petition. And the honorable single judge have allowed the writ petition, thereby setting aside the order of termination.
May I take your lordship to page 18, para 7. That is the finding of the Honorable Single Judge. Having heard the learned counsel for the parties and taking into account the stipulation contained under Annexure 2, it is the view of this court that the petitioner has not suppressed anything in his affidavit as required in the advertisement. The petitioner submitted the affidavit by indicating therein that he has only made his application in respect of Dhenkanal Education District coming under the Dhenkanal Revenue District, since the advertisement under Annexure 2 is not very specific, asking the candidates to file an affidavit that he has not made any application in respect of any education district coming under any other revenue district. The stand taken by the opposite parties while disengaging the petitioner is not sustainable in the.
Where is the advertisement?
My lord, may I take your lordship? The advertisement is at Annexure 2 to the writ petition, which is in vernacular language, my lord. But before that, I'll take your lordship to page 40 of the writ appeal, which is the government resolution and the guideline for engagement of Sikhya Sahayak. And the advertisements were issued pursuant to this guideline. That is at page 42.
Yes.
Page 40
Page 40 of the writ petition.
of the appeal petition.
Which is part of that writ petition.
Yes, ma'am.
All right.
Annexure 2 is the exact advertisement of the district to the writ petition, which is in vernacular language. But this is the guideline.
Resolution.
Page 40 is the guideline basing on which the different districts had issued their advertisement. So I'll take your lordship to page 42, the relevant portion, that is mode of application. Para 5.1. Applications will be invited from eligible candidates registered with Employment Exchange, public state employment exchange, as the case may be.
Page 42. So, mode of application 5.
To advertisement in local newspaper by respective collector cum CEO Jilla Parishad. A candidate may make an application for any education district unit of the state irrespective of his or her home education district, subject to condition that he/she shall apply in respect of one education district unit only. Application will be submitted in the following ways before the respective CEO Jilla Parishad. Then the candidate shall have to furnish an affidavit with his/her application to the effect that he/she has not made any application for engagement of Sikhya Sahayak in any education district unit other than the education district unit applied for. If on verification it is found that the candidate has applied in more than one education district unit for engagement as Sikhya Sahayak, his or her application will be rejected without assigning any reason thereof. But this is the condition stipulated.
And the advertisement you read out.
Well, the advertisement that is at Annexure 2 of the writ petition, that is in vernacular language. That is
Read out that portion. Page.
that is page. In fact, my learned friend has
I have
also
given annexure page 14 to my counter.
Whichever.
I have annexure 14. Sir, page 14
page 14
to my counter, my reply.
to the affidavit reply.
By my,
That is filed
I have
by
annexed.
my learned senior friend. That is at Annexure A by 1.
A by 1, page 14.
Lordship,
Not very clear. So any one of you please read it.
because the writ petition, the
No, I am-
advertisement is also not clear, my lord.
Yes.
So
Dhenka. In my form, I can.
Got it, but difficult to read. So that is why I'm saying read.
I am reading.
So whether there is any reference to the resolution in the
No,
advertisement?
no motive. I can clearly nothing mentioned. I am reading, madam. ଢେଙ୍କାନାଳ ରାଜସ୍ୱ ଶିକ୍ଷା ଜିଲ୍ଲା ଗୁଡ଼ିକର ପ୍ରାଥମିକ ଓ ଉଚ୍ଚ ବିଦ୍ୟାଳୟ ପ୍ରାଥମିକ ଶିକ୍ଷା ଆବଶ୍ୟକ ନିୟୋଜିତ ପାଇଁ ଢେଙ୍କାନାଳ ଜିଲ୍ଲା ପରିଷଦ ତରଫରୁ ଦରଖାସ୍ତ ଆହ୍ୱାନ କରାଯାଉଛି ଇଚ୍ଛୁକ ପ୍ରାର୍ଥୀ ବା ଯେକୌଣସି ଗୋଟିଏ ଶିକ୍ଷା ଜିଲ୍ଲା ଆପଣ ଆବେଦନ କରିପାରିବେ
ହଁ ହଁ ସେଇଟା କଣ?
ଆବେଦନ ପତ୍ର ସହିତ ପ୍ରାର୍ଥୀଙ୍କର ଗୋଟିଏ ଶିକ୍ଷା ଜିଲ୍ଲା ଆବେଦନ କରିଛନ୍ତି ବୋଲି ସତ୍ୟପାଠ ଦାଖଲ କରିବେ ସଂଲଗ୍ନ କରିବେ ଯଥା ସମୟରେ ଯଦି ପ୍ରାର୍ଥୀ ଯାଞ୍ଚ ସମୟ ଯଦି ପ୍ରାର୍ଥୀ ଜଣେ ଆବେଦନ ଶିକ୍ଷା ଜିଲ୍ଲା ଗୋଟେ ଅନ୍ୟ ଶିକ୍ଷା ଆବେଦନ କରିବା
ଆସ୍ତେ ଆସ୍ତେ ଆସ୍ତେ
ସରି ଯାଞ୍ଚ ସମୟରେ ଯଦି ପ୍ରାର୍ଥିନୀ ମାନେ ଆବେଦନ କରିଥିବା ଶିକ୍ଷା ଜିଲ୍ଲା ବ୍ୟତୀତ ଅନ୍ୟ ଶିକ୍ଷା ଜିଲ୍ଲା ଆବେଦନ କରିଥିବା ପ୍ରମାଣିତ ହୁଏ ସେ ପ୍ରାର୍ଥୀଙ୍କର ଆବେଦନ ପତ୍ର ବିଚାରକୁ ନିଆ ନଯାଇ ନାକଚ କରିଦିଆଯିବ।
What else?
Madam.
What else? Even I can understand.
Madam.
That is why I said read it aloud.
Sorry.
If I mean,
What is left?
ଇଚ୍ଛୁକ ପ୍ରାର୍ଥୀ ମାନେ ସାଧା କାଗଜରେ ନିମ୍ନ ପ୍ରଦ ଦରଖାସ୍ତ
And if your client cannot read that, understand that, who must be belonging to this state, then he should not continue.
that is their advertisement. That is their advertisement. We have collected on by option paper. They
Mr.
have not annexed. They have not annexed.
Mahanti, if your client could not understand this, he does not deserve to be serviced.
They have only in the advertisement stood that
If your client
there are three education districts about Dhanagar.
Counsel, if your client could not understand that, which I could understand, then why should he continue?
He has understood. Well, nothing is mentioned regarding the resolution was my friend has relied. Nothing
No.
mentioned.
That is necessary to be mentioned. If nothing is there in the advertisement, they'll say that refer to that notification for further details. But
Ma'am.
here they have clearly mentioned.
Nothing mentioned. They have in the advertisement, nothing is mentioned regarding the resolution of government. That is an enter case.
All right.
Nothing is mentioned. And that Dhanagar education district is constitutes 3 education district. Dhanagar Revenue District. I have applied 1 education district for of Dhanagar district, my lord. And the allegation that in 2000 that is 2011.
So if you have applied for one district,
My lord.
then there is no problem. Then why did they remove you?
They have selected.
Then why you have made only application only
Yes.
for one district?
Yes, my lord.
What is he saying?
They said in the Jajpur district I applied. So it is separate advertisement 2012 by Jajpur collector.
Not in 12.
That
So
is-
far as Jajpur district is concerned, he applied first. If your lordship will go to the resolution says education district unit. So Jajpur education district unit he applied. Then subsequently he applied for Dhanagar district.
But if
Dhanagar
the
district he filed an affidavit that I have only applied for Dhanagar education district. I have not applied for any other district. Then when the SOCOS was issued, your lordship may kindly see page 46. He has admitted that he has applied for 2 education district.
no, admitted because that is a fact he's admitting, but he is saying that he did not understand that that you meant only that advertisement.
He made out a case in the writ petition that Dhanagar revenue district, that is not the
No, revenue district can't be. Dhanagar is one education district.
education district unit.
All right.
A education district unit consists of different district education
3
districts.
education district.
Dhanagar is how many?
Tinta is. Yes.
Dhanagar has 3 education
My lord,
districts. And Dhanagar as such is a education district unit.
Okay, so
So once you have applied for Jajpur and your application was accepted and you applied for Jajpur as per the government resolution that is 5.1, he should not have filed for another
No,
education
but why
district.
are you relying on the government resolution when the advertisement is very specific on this? When the advertisement says that if it is found later that he had applied in a different district or a different district unit, then his application shall be, his candidature shall be rejected or something, cancelled. Was that not there in the advertisement?
you read out the advertisement. Because it is said, since the advertisement is clear, you don't have to go back to the resolution. Advertisement is based on the resolution, but advertisement is clear.
See,
But
when
the
single judge,
advertisement,
just a minute, when single judge has allowed the writ petition on the reasoning that there was no stipulation in the advertisement that you should file an application, that you had not applied in any other district education unit.
District.
District education or education district unit. All right. So this is the reasoning given by the learned single judge, that there was no requirement to declare that you had not applied. The requirement was so clear in the advertisement that it clearly prescribed that if it is found later that you had also applied in a different, in another education district, your candidature shall be cancelled.
Right.
Is it not that?
Yes, I can.
Then the advertisement is clear that there is the question.
Advertisement means for 3 education district. Advertisement, ढेंकानाल district consists of 3 education district. From the 3, I applied only for 1. That is the finding on travel on no single judge. From the 3 education district, I only applied ढेंकानाल. There are 2 other Kamakhya, Hindolo, Kamakhya Nagar. 3 education district, out of 3, I applied only for 1. That is the finding on no single judge.
See, in Kanda,
Possible to get, because had it been a common advertisement, possible. So only on that ground it has been done. And is there any other thing that he suppressed in his application?
No, only the affidavit. He has enclosed that affidavit.
So read out that read out the affidavit.
Yes, madam. That affidavit is at page 45
Read it
of the
out.
appeal.
Yes, yes.
when was Jajpur advertisement issued?
Madam, that Jajpur advertisement is not part of the record.
And just a minute, when was that?
He must have
If that is
stated.
not part of record, then why this? Jajpur was, do you have any idea when was that issued?
To my install 2012.
Same year.
No, 2012, 1 year after.
After,
Yes, to my install, it is issued 2012.
Have you
I
seen
was-
it anywhere on
More,
affidavit?
I have mentioned in my reply that this is after the advertisement issued by ढेंकानाल. After 6 months after they have advertised in Jajpur, I had only applied. But in the meantime, I selected in the ढेंकानाल. I have never even submitted document there also. Merely I applied only, nothing else, madam. That is finding on a single judge. That's what he has not suffered anything because of the 3 agent district. He applied for 1.
Which one? The
And
the advertisement or which one?
advertisement.
Yes.
Can you give us English translation?
Yes, madam.
ଶିକ୍ଷା ଜିଲ୍ଲା ପାଇଁ ଆବେଦନ କରିପାରିବେ
I will
ତାପରେ
give the English
ଦୁସୁନି
translation.
ତାପରେ ଦୁସୁନି
I will give the English translation.
ଆବେଦନ ପତ୍ର ସହିତ ପ୍ରାର୍ଥିନୀ କେବଳ ଗୋଟିଏ ଶିକ୍ଷା ଜିଲ୍ଲା ପାଇଁ
Right.
so one education district ପାଇଁ ଆବେଦନ କରିପାରିବେ ବୋଲି ଏକ ସତ୍ୟ ପାଠ ସଂଲଗ୍ନ କରିବେ ତାପରେ କୌଣସି ସମୟରେ ଯଦି ଯେକୌଣସି ସମୟରେ ଯଦି ପ୍ରାର୍ଥିନୀ ମାନେ ଆବେଦନ କରିଥିବା ଶିକ୍ଷା ଜିଲ୍ଲା ବ୍ୟତୀତ ଅନ୍ୟ ଶିକ୍ଷା ଜିଲ୍ଲାରେ ଆବେଦନ କରିଥିବା ପ୍ରମାଣିତ ହୁଏ ତେବେ ପ୍ରାର୍ଥିନୀକାରୀ ଙ୍କ ଆବେଦନ ପତ୍ର
ଯାଞ୍ଚ ସମୟରେ
ନାଇଁ ଦିବାଗତ ବି ନିଆଯିବ
ଯାଞ୍ଚ ସମୟରେ ଆବେଦନ ବିଚାର ନିଆଯାଇ ନାକଚ କରାଯିବ।
ଯାଞ୍ଚ ସମୟ କାଇଁ
ମ୍ୟାଡାମ ଉପରେ ପ୍ରାର୍ଥୀଙ୍କର ଯାଞ୍ଚ ସମୟରେ ଲାଇନ ନମ୍ବର 4
ଓକେ ଓକେ
ମ୍ୟାଡାମ କ୍ଲିୟର ମେନସନ ଫର
ଦିବାଗତ ନଯାଇ ନାକଚ କରିଦିଆଯିବ ସାର୍ଟିଫିକେଟ
ଜାଲ ବୋଲି ପ୍ରମାଣିତ ହେଲେ
that is separate. Number is relevant is that portion.
only that person ମ୍ୟାଡାମ
So that is not clear, Mr. Das. Forget about the case. On a mere reading, a person can be confused.
Produce the English translation.
See, the matter would have been different had there been one advertisement. Or had there been 20 advertisements issued simultaneously, the matter would have been different. But here, even the year is different and you are not sure.
Well, that your year with respect to Jajpur district, that I'll produce that document.
No, that we
Because-
cannot see.
Because that
Now
was the
the writ petition has been decided.
page
and we have
38,
to,
page 38 of the appeal. That is the report which was furnished by the block education officer of
38.
Jajpur district. Your lordship may kindly see page 38.
no, why should we see Jajpur? Why should not we confine ourselves to the advertisement? The resolution, you are relying on resolution.
Yes.
Did you refer in your advertisement that this recruitment process is being conducted in view of that resolution?
That is not referred in the
All right,
advertisement.
then don't blame him because he might have committed a mistake. And we are prima facie satisfied that there was no wrong on his part.
But he admits in its.
He admits, so because he's done it, he admits.
In the so-called affidavit,
Yes.
he admits. that
Yes,
For Jajpur district,
yes,
he was an applicant,
yes.
but later he applied for Dhenkanal district. That is what now.
Now you're saying just the opposite.
Just the opposite. That is what your lordship can kindly see the so-called affidavit. So that is why I say that advertisement of Jajpur district, so also
whatever-
Dhenkanal district will suffice if produced before my lord. appreciation.
Whatever he is saying, the question is of
In his anxiety, he's going beyond the record, which he should not. But
If your lordship will just have a glance to page 38, page 38 will suffice your lordship may kindly see.
not in this.
Another point, my lord, in the meantime, I have promoted to junior teacher during pendency of the case 2016. In the by them without any court order. I have promoted junior
that
teacher.
is immaterial.
In the meantime, during
Yes,
pendency of the
that
case.
is immaterial.
No, no.
We are seeing your entry into the.
My lord.
Your lordship may kindly see page 37 first. This is by the district project coordinator Jajpur. To the district project coordinator Dhenkanal. With reference to the subject and letter cited above, I am to say that the following candidates have applied for the post of CSI under different education districts of Jajpur district. Detail of their application is mentioned below. Serial number 3, the name of the petitioner. Then, my lord, next page 38, that is the SOCOs issued to the petitioner. Inviting reference to the letter number so and so, I am directed to intimate you to read the following words. Read DPO SSA Cuttack so and so Jajpur and Athagad Education District as Jajpur Education District under Jajpur Revenue District. Because you had applied for the post of Sikha Sahak in Jajpur Education District simultaneously in Dhenkanal Education District. So that is why he had not he has not annexed that document of Jajpur district because both the advertisements were issued simultaneously.
Where is that?
No.
So that is why I said, my lord, that advertisement is required to be produced if it is for a different education district,
And
different recruitment year.
Had there been some clear stipulation in the advertisement, the matter would have been different and we could have considered interfering with the, not in this case. And even if we find that there was some mistake, we will not. All right. This was-
Item number 6.
The appellant is the Odisha Water Supply Storage Board. The important order passed by the Honorable Single Judge in relation to regularization of the daily wages. And the similar batch of writ appeals I have already filed and you are listed for Lordship last week. Lordship was pleased to pass this order. Lordship. Total 33 numbers of writ appeals have been filed, my lord. So prior to this, my lord, all except these writ appeals, all those writ appeals are listed and this order was passed.
Same organization.
My lord, I am appearing in item number 6, 9, 12 and 15. I have entered my appearance. Let him soft copy. It will come up on 13/8.
Four matters.
4 matters. 6, 9, 12, 15.
I'll solve copies of the.
Sub items.
There.
Sub items.
I am also appearing, lordship in writ appeal number 670, 870 and 862.
Is your name appearing? Then you give a cheat otherwise. Or not a night. Have you filed wakalatnama?
Just filing today.
You will file today.
Yes. Your lordship. In another writ appeal. Yes. Another writ appeal, your lordship.
Another writ appeal you want to file wakalatnama here?
Writ appeal. One employee challenged before the Honorable Apex Court, and Apex Court set aside the earlier writ appeal and directed for hearing the matter.
The writ appeal was again restored.
Restored at court. The batch matter should be had along with this writ appeal.
So this,
Has to be tagged.
Where is this order of the division bench?
Order of the division bench executed. Order of the division bench is received. Discipline
36, 2021. Austin WA number 423 of 2020.
20.
This is the order of the earlier order.
Which has been set aside by Supreme Court.
Yes.
Yes.
All the matters has been posted to 13th August. So let him stop the copy.
On 13th August, please don't seek any adjournment.
Sure.
Because it is very difficult for us to give a particular date.
No adjournment. It will be hard. Let him solve the copies, my lord.
I'll solve.
Writ appeals.
Today I am appearing also in two writ appeal, 862 and 870 of 2024. I am two writ appeal.
All right, all right.
862 and 870 of 2020.
File in the Wakalatnama, file in the registry.
Registry.
But give the case numbers in a slip.
Yes.
And your name, please also.
Item number 7.
May I please listen? So Lordship, on last date, has wish to give direction to file counter to the opposite part number 1.
What is this about?
Lordship, I'm up. May I please, the Lordship? Lordship, I'm appearing for the opposite party number 9 in this case, my lord. The read petition mostly regarding the main prayer is for disposal of representation. But as the Honorable Court directed in the first order, my lord, as the Honorable Court sought a reply with respect to the observation made by the Tahsildar in Annexure 5, my lord, we are filing a counter affidavit.
My lord, no counter.
Serving a copy to the petitioner, my lord.
My lord, kindly give me some time to go through the counter. Kindly give me some time to go through the counter.
Lordship, if Lordship allows me, I can file it across, or I'll file in the top box, my lord.
What is this?
This is a counter affidavit on behalf of opposite party number 9, my lord.
Counter affidavit. File in the registry.
Grateful, man.
On behalf of the state.
Opposite party number 9, my lord.
Opposite part number 9, the file is with the registry. It is stated by counsel for the petitioner that he has received the counter affidavit. And he wants to consider the same and file reply is so required. Yes. Post office this matter on 2 weeks.
So Ms. Patnaik state doesn't want to file counter affidavit.
Sure,
Twice
with-
time has been granted.
1 week, your lordship. File count.
May do it. In the meanwhile, will be open for the state to file counter affidavit.
Grateful, my lord.
Item number 8.
May I please, your lordship? Here, your lordship, my lord, may kindly take glance over the order dated 25th of May. Lordship, this matter relating to that public interest litigation regarding implementation of that annexure 1, that is the scheme, namely Mukhyamantri Kalakar Yojana.
Yes. So whether affidavit has been filed?
No, your lordship, I seek 2 weeks' time, your lordship, to file an affidavit.
Yeah. Other time is allowed for the state to file counter affidavit. Oh. Why are they taking so much time?
Your lordship, before the vacation, elections was there in the meantime, your lordship, now we are regularizing it. I've sought for instructions, your lordship,
During
within
the
a week.
election,
That's why.
during the election, the elections were there.
Your
Now the
lordship,
elections are over, the elections are over.
over, your lordship,
After
I've
some time,
sought for
you will have some
instructions.
holidays.
I've sought for instructions within a week, I'm filing.
Your
For last 6 years, the indigent and old age artists, irrespective of their performance and finding of eligibility, they are not being able to get their scheme of the government. I pray the implementation of the scheme, of their own scheme. Not saying paying for anything beyond the scheme or beyond the rules.
The problem with the schemes, they take it personally. They will change the name of the scheme and give it to you.
we are helpless. We don't have, if your government decides not to cooperate, not to file affidavits, then
Lordship, this had come
Yes.
before the vacations come before me for the first time. I'll ensure it, and I reply by 1 week, your lordship. Maximum 1 week, your lordship. Yes, your lordship.
Item number 9.
There are 1 week time, my lord. Additional affidavit will file, my lord. I'll file the additional affidavit.
what for?
For collect of the tribunal order, my lord. So that's your last occasion, your lordship directed to file the additional affidavit.
1 week time for filing additional.
1 week after, my lord.
Item
Yes.
number 10.
Always.
Item 10, my lord, on behalf of Mr. R.C. Mahanti, my lord. The I is operated may be
Please
taken
tell how much time do you want?
Documents are
On
adjusted
Monday,
to
my lord.
clarify my case before lordship. Your lordship may kindly have it. Appreciate my documents. My documents are very exhaustive, my lord. My prayer is very simple.
Which
my lord.
matter? He is seeking, you are seeking adjournment.
My lord,
Yes, my
It's
lord.
for
on
the
behalf of
opposite
Mr.
party,
R.C.
but this we have
What was
expressed. We have expressed what is the urgency. You are not giving NOC.
Yes, my lord. We have sought for instruction. Only on Monday,
Only this is not the first date it is being listed.
it was listed on last second. my lord.
I have sought for instruction, my lord.
My-
And he,
Let
his,
instruction not come.
his document also shows that in respect of 7 deficiencies, he has complied with 2 deficiencies. His document, unnatural 5.
No, that is not my case, my lord.
Because of the urgency, we had granted 1 week time.
Annexure
For DMT.
Annexure
Yes,
3, Annexure 3 shows that 7 deficiencies
So
are
whatever
there.
it is, you find it. So Thursday or Friday.
Why don't you reject his case? Take a decision.
Yes, ma'am.
But why should you keep something pending like this? It's a matter of educational institution.
Yes, ma'am.
With that observation, what your lordship have been pleased to say, so with that observation, it might be disposed of.
We
That-
don't know.
That they can reject.
No,
We'll
no,
direct
Miller.
that. Or what, that is
They
the,
have to take the final decision, Miller. Because they are keeping my case pending, Miller. That is headache as per your lordship guideline, Miller. That has been decided by your lordship in that comprehensive judgment. And
Let them deviate
Oblige,
from
Miller,
that.
oblige.
Let them disobey that. Let them do something. Requested on behalf of the DMET, list this matter on.
9th.
Yes, Monday.
Item 11.
May I please? Listen, I am noting that counter not filed. In fact, they have filed. Saw a copy of the counter on me.
On time.
No, I have already prepared it.
Tell
I have
me.
to give in course of the time agenda. Let's call it day after tomorrow.
Whenever.
Day after tomorrow, man.
Submit
Oh, yes,
for
sir.
him.
My lord, I am appealing for the interim. I file a interim application.
When do you want?
But I'm one of the successful technical bidder, my lord.
You
My
received the
agent-
counter.
I'm sorry.
I have received the counter, man.
Yes. So
I
what
have
do you
filed-
want? Because
Course of the day, I filed a rejoinder affidavit, man.
you will file. So when do you want to say? Because
My lord, that's.
you have.
I want pray that the day after tomorrow, my lord, because the auction per sale is. Final.
Your Lordship, there has been suppression of facts in the affidavit,
In your affidavit.
in their affidavit, Your Lordship.
I have explained. I will explain in my rejoinder. I have not suppressed anything. I reply that.
No, is there any interim order? No, they'll proceed with it.
No, that is what I'm saying. There is no interim order, so unless we hold it out, it will.
Fifth, my lord. Fifth afternoon.
Fifth was Friday.
As requested on behalf of the petitioner, there's this matter on Thursday.
Item 12.
Okay.
Might please, Your Lordship.
Yes.
Lordship, these are the pictures of the pictures of an artificial flood which is created by opposite party number 8 and 9 through making obstruction over a drain. And against this act of the opposite party number 8 and 9, the present petitioner moved to the High Court of ADCP cum Executive Magistrate Bhubaneswar under section 133 of CRPC.
But is this only in your house? I think Bhubaneswar, once it rains, it happens in a lot of colonies.
It affects around 40 localities, Your Lordship.
40.
40. 30 to 40
Because of the
localities.
construction over the drain.
No, there is a drain left in the soft plot,
Yes.
but opposite party number 8 and 9 are private party. They are making obstruction over the drain.
I'm asking that, you're saying no, they are making construction over the drain. What is this? Okay.
There was already an order under section 133 CRPC for removal of those unauthorized construction by the executive magistrate.
Yes.
Now the present case is filed alleging that that order has not been implemented. And for that purpose, he has filed a petition under section 141 CRPC before the same magistrate. That was refused. Against that, he referred CRLMP, I think.
CRLMP.
That was disposed of. And how this REIT is maintainable, because these are all interstate private disputes. Executive magistrate is a for quasi judicial authority.
Private dispute drain is whose property? Private property.
No, that is why the magistrate has, for non-implementation of the order, there is a provision under section 141. And he has rightly sorted taken resort to that provision. That was refused. Again, that he has preferred the Honorable High Court in CRLMP.
May I please, Your Lordship? Lordship, the 141 CRPC application is not, they are not accepting that petition. They are saying that we do not have any expertise to deal in such matter. I multiple of time I have filed the petition before them, but they are not accepting this petition. Where there is the absolute
How do
remedy.
you file?
Lordship,
How do you file your application? Where is the question of refusal?
Lordship, they are not accepting.
No, accept means you are giving in somebody's hand or what?
No, I am filing multiples of time, but
How are you filing?
Lordship, the e-filing system is not there, but magistrate endorsed this application, but they are not just there. They just hear, but no, not accepting it.
Means what? How do you go there, go to hand over that application to the PN or the officer, or you send it
Through the
send
due
it to
process.
registered?
Through the due process, sir. The normal way, how
the
we
due
file the
process?
application under section 133 of CRPC, in the
Mr.
same
Counsel,
manner I have filed.
how did you send the your application?
No, physically.
Physically means what?
Lordship, they are not just.
No, we are curious because you are saying 133 was registered. Thereafter, you are saying 141, they are not accepting.
Yes.
So we want to be sure that what you did that they are not accepting. How did you offer it? Or how did you file it?
Normal process.
Again, normal process. If you don't know,
What
you
is
don't know.
normal? What is abnormal?
नॉर्मली मीन्स मैं सब नॉर्मली जैसे 133 फाइल किया गया था कोर्ट के पीएम के द्वारा उसी तरह से फाइल किया था.
And what is abnormal?
They are not accepting. They are not just not, they are not accepting.
You have
Multiples of
stated-
time I have filed this. After Tinath Ponda judgment from this honorable court, I have also filed that application on dated 28th of March 2024.
Before whom?
Yes, what is your system?
The London Magistrate Court.
My lord, I don't know if he has filed because it is to be registered as a criminal miscase before the executive.
No, he says he was told that since we have disposed of the application, further application is not maintainable here, you go to the higher forum.
141 could be a new proceeding.
This is
No, but something has been done in 141 proceeding.
That is not borne out from the records.
So, and then what did he come for here for?
Yes, that is the more. He has not annexed for what he has filed the CRLMP before the honorable single bench. That is not disclosed in the writ petition.
Why did you file?
Yes.
That is only certificate is there.
Honorable single judge are directed to exercise the provision remedy available in CRPC.
Yes.
So, Lordship, I have the copy.
But that is not mentioned in the.
Multiples of time I have filed this petition, Your Lordship.
multiples of time is you only remember when the rainy season comes. The order has been passed in July 2023. Again, this July you have
Lordship,
become active.
Around 3 or 4 times I have filed this petition before. I have also annexed in annexure number 6 and 5 and 6 in the petition. 2 or 3 numbers of time. Also, I have presented the copy of the judgment, that is Tirnath Ponda versus Commissioner Health Secretary of the State of Odisha.
Annexure 5. There is no annexure 5, there is 5A. 5A, 6A. Index says 6A, annexure says 6. What is the problem? I can't understand. कौन है जी index को?
So what is the order in that case?
That is not reported. That is the more.
Where is the second?
Yes. Second page again.
It is.
अच्छा.
So I think similar prayer has been rejected by the honorable single judge. That
Yes.
it is
So how much cost?
So
What
how-
is this you had approached?
how the case
And the High
again
Court
could be
declined.
filed before the
Again,
division bench.
For after this CRLMP has disposed of, I again approached to the learned court, but they are not endorsing into the record. My application is not and been entertained.
Then the matter should be again referred to the single
They-
judge.
they-
That
they-
is my responsibility.
Also, they can file an
How-
affidavit, then why they are not accepting?
Mr. Counsel, you are a lawyer. And we are rather shocked to hear from you that someone is not accepting your application.
Lordship, unfortunately, the e-filing process is not there in
Very
ADCP
good,
court.
It was not there for so many years. What were
Very
you
good.
doing?
Very good. When will you go? When will you go today to give the application? When?
Lordship, on 28th of March.
Today, when will you go to him?
If the learned magistrate is ready and willing to accept this petition,
Oh.
then within 1.5 hours I can be there.
Go and give. At
Lordship,
4.
may kindly
Ask-
give in direction.
By 4 p.m. you-
What is this? You could have sent through registered post. Did you do that?
Yes, I have sent through
For
registered post.
everything, courts interfere.
Where is it?
Intervention.
Lordship, it is annexure number 3, page number.
Then we are asking you since so long, what are you doing?
Exactly. We are
Page number 27, Lordship, may kindly have a glance. Through
Page-
registered post, I have sent them.
Page?
Page number 27, Your Lordship. Postal receipt is also annexed.
That when we are asking you so many times, this is what you should have shown us.
Sorry.
May I submit one thing?
What?
What has happened, as far as my personal
You have
experience
understood,
goes,
yes.
what he did after disposal of the 133 proceeding, he filed a IA arising out of, just like High Court style, arising out of disposed of case.
So
number.
that obviously they didn't take because.
Yes.
Yes.
So he could have filed a fresh application by another CMC under section 141. I hope.
Where is your application under 141?
He has filed IA number so and so arising out of CMC numbers, the disposed of case.
Page number
That is, I think, not.
Page
Did
number?
you file your
32,
Page 36.
32 and 36.
36. I think for that purpose, only to assist my learned friend, let him file a new SCMP. I'm sorry, CMC
No, look at page 32.
32.
No, he has put the earlier number and said.
Yes, earlier number.
Petition
that is
under section
disposed of.
141.
That is disposed of. That 1237 is already disposed of.
I have also filed the
So,
fresh
question
application
is after
also.
disposal of the original case,
This-
whether the magistrate could have accept any application under section 140 without any nomenclature of a new, assigning any new number. That is only, he can, I think the problem will be solved if he can file a new CMC with new number under section 141.
He cannot give the number.
No, that will be registered as a new CMC number. Just like 1237 under
The
section.
problem is they are not accepting. They are not registering to my case. Simply they are not registering. I should not come here if the absolute remedy is available in a 141 of CRPC. Lordship, I have also presented this judgment before the learned magistrate court.
Again, how?
the
The physical,
petitioner?
I also prayed them to, if you are not entertaining, kindly reject this.
Clear approach this. Did you file a petition?
Lordship,
The petitioner has filed present writ application in the nature of public interest litigations, directing the opposite parties number 5, 6, and 7 to execute an order dated 7/7/2023 passed by OP number 4, ADCP cum executive magistrate wide CMC case number 1287 of 2022 under section 133 of the CRPC against private opposite parties number 8 and 9. Full stop. It appears that before filing the present writ application, the petitioner had filed a case before this court giving rise to CRLMP number 2337 of 2023. Stop. This court disposed of the said application with an observation that it was not a fit case for exercise of plenary jurisdiction under Article 226 of the Constitution of India. Stop. The court, however, observed, the learned single judge, however, observed that it shall be open to the petitioner to pursue the remedy available to him under the CRPC. Stop. Thereafter, the petitioner has filed present writ application in the nature of public interest litigation with a grievance that the opposite parties are not accepting the application which he is filing under, which he has attempted to file under section 141 of the CRPC. Stop. Next, Appellant counsel appearing on behalf of the petitioner has submitted that the petitioner attempted to serve copy of the said application under section 141 of the CRPC by handing that over to the peon of
କାହାକୁ ଦେଲେ petition ଟା ଯୋଉ କହିଲେ ଏମିତି ଦେଲି
ADCP कम executive magistrate भुवनेश्वर
peon, उसके peon को दिया.
पियन हाँ पियन
So stop. In the court's opinion, present application in the nature of register post से भी भेजा.
yes
Huh?
lordship
Where is that evidence?
lordship
Where have you said?
to DCP भुवनेश्वर to DCP
receipt page annexure is receipt.
it is in annexure number page number 30 tracking ID is page number 30 and letter
This you have this you have sent to the acha
DCP
IIC Bharatpur and the DCP.
yes
So DCP is the executive magistrate.
yes lordship yes
Yes. Also, what is the date?
Date is 15/12/2023.
He has also submitted that a copy of this said application has been communicated to whom?
to DCP भुवनेश्वर
Representation. You have not sent the application. You have sent the representation.
application
Quick.
page number 27 your lordship
Those are your representations for executing the order of the ADCP come executive magistrate.
yes lordship
Please go to the notice. CRP secretary.
So you are required to give your application to the magistrate under Form 141. Executive magistrate. Okay. Say again. Next, be that as it may, in the court's opinion, this writ application in the nature of public interest litigation filed after disposal of CRLMP number 2337 of 2023, seeking similar relief is thoroughly misconceived. Stop. Where is the?
Postal receipt.
No. Where is your application to the executive magistrate?
I have sent it to
Page 32.
DCP DCP
Page
Bhubaneswar,
30.
page 30.
ACP 141, have you read?
Yes, Lordship, DCP also have the power of executive magistrate. Lordship, I have annexure number 7. May I kindly have a glance. Annexure 7, page number 42, point number 2.
So you have filed your application under 133 before whom?
ADCP come executive magistrate.
Huh? Filed
ADCP.
before him, 140.
ADCP.
ADCP.
That's for him here, that is annexure 5 and 6.
Yes, so 133, the person before whom you had filed your application under 133, you will have to go before him. What is the system? Why your office?
That ADCP is holding a court. And another point of law which I want to raise, your lordship. This 141 section is only to enforce order under section 136 and 138. Your lordship may read. That is a matter to be dealt with by the executive magistrate once he files a petition.
So 133 thereafter is remediless.
No, not remediless, but 141, which he is.
Oh, forget 141. Then what is the remedy?
That is other, but 141,
What is the remedy?
which I read from the 141.
No, all right. What is the remedy after
That
133?
188 is that when the matter is, there is a violation of the order, the magistrate can file complaint against the.
Mr.
But
133
he
is
should
not
file
the order.
a press case.
The order must have been under 136.
133, if you want to enforce it, he must file a press case. I hope the matter will be accepted.
But what kind of grievance is being raised that no one is receiving?
Also, a fresh case I have filed, but I have not annexed it.
Number, new number.
They are not accepting it. That is the issue.
Liberty to make success application before
ADCP.
What is ADC?
Additional Deputy Commissioner of Police.
Additional Deputy Commissioner of Police is the executive magistrate.
Is a executive magistrate.
Executive magistrate
Bhubaneswar.
for removal of the encroachment. Yes.
That will suffice.
Removal of encroachment for enforcement of the orders said to have been passed under section 133 of the CF.
Item number 13.
13, may I please, your lordship?
13 lordships are pleased to ask me to obtain instruction with regard to that a proceeding is pending before the collector after the judgment of the Sonal Court. The collector has initiated proceeding and notice has been issued to party. That is miss case number 10 of 23 minutes. And now I have obtained instruction. It is stage of disposal minutes. So may grant me some time so that it can be sorted out. The land will be given for smotion and for the bus stand equally minutes.
So what is the direction?
The direction is lordship to kindly look at the judgment at
Page 19, if your lordship can. Page 19, paragraph 10 and 11.
When was the order passed?
But the order was passed
On 10th February 2023.
Yes.
What is the order? Paragraph 10?
Paragraph 10 and also paragraph 11.
Which part of the order has been complied with?
Well, neither, both the part has not yet been complied.
Was this a PL?
Yes, ma'am.
PL?
In the nature of PL, but they filed saying that
Under the OGLS challenging the alienation of smosan land.
alienation proceeding.
Alienation of?
Alienation of Smashan land and handing over to the transport department without.
Their allegation is that land is earmarked for Smashan. It has been handed over to the transport department for construction of a bus stand mirrors. And this also directed that until and unless this Smashan land is not properly demarcated, no bus stand can be constructed. That is why as the collector has not taken a decision, because bus stand is not being constructed over that land mirrors. And the proceeding is going on. They have been noticed. After disposal of that case, only question of construction bus stand will come.
No, that is why I was asking whether it was a PIL or a.
No, it's under the OGLS Act, they had filed a petition saying the alienation in respect of social land cannot be done.
Yes, there is no non-compliance. They have not done anything. Therefore, there is no non-compliance. You did not want there to be a bus stand. Unless Smashan was demarcated, they have not done anything. So no contempt.
In fact, this 36 decimal of land taken from this Smashan exchange, they have not given.
But bus stand has also not been constructed.
No, bus stand, my lord, what they have done, they have alienated for entire Smashan land for construction of the bus land. This honorable court in the earlier judgment has said this alienation is bad and you first give out the exchange 36 decimal of land as per the 1988 land acquisition proceeding.
But that is subject to opposite party number 3 are directed to first complete alienation.
We have said that this Smashan has been taken back. And now this court has said, unless you make the alternate arrangement as per 2011 decision, no steps can be taken up. Now they are not giving the exchange 36 decimal of land.
They are not doing anything. They are not establishing their bus stand there.
This is the second part of the prayer, my lord. The first part is from 1988, the 36 decimal which you have taken, you have not given. Page 10, my lord, paragraph 10, that the exchange land should be given back. And it should be earmarked as Smashan land. They are not doing that.
Yeah. No, we are not satisfied. The
order will remain uncomplied unless.
Which part has been not complied?
My lord, paragraph 10.
What is there in paragraph 10?
Paragraph 10 that 36 decimal in plot number 3341 recorded as Savik 49 ensure access of communal user. My lord, this land has not given now.
Mr. Counsel, what is there? What direction is there? First complete. First means then what?
Thereafter, they can take up alienation proceeding, giving out the alternate.
They are not doing anything.
Have they done the second part before paragraph 10?
They have taken that step. That's why I have approached. If the subsequent.
What step have they taken after this order?
Well, they have taken steps. In fact, they have. If your lordship will.
Mr. Counsel, after this order, what step has been taken?
Malad, the page 21, 22, 23 may be seen. They have used machineries, make it parallel.
20 is part of that order.
20,
Yes.
21.
What is 21?
These are the photographs, my lord, annex. They have used heavy machinery, make it parallel.
When? Then what is the date?
My lord, that date I have not mentioned.
That date I have not mentioned. Where is contempt? Contempt leads to punishment of a person.
If
Not
your
on the
lordship
basis of
permit
some
me,
photograph which you have taken.
if your lordship permit me, I can file additional affidavit, my
You
lord.
can file later. Now we are, as on date, we are not satisfied. The petitioner had filed the writ petition with a grievance that plot number 3097 in Hal Khata of area 88 decimal having Kisam Samsan has lost its character since long and had lost its character since long and was not being used for that purpose. Oh. Assam was directed to be changed to Parita,
Patita.
Patita from Subsdharana Khata to Abad Jogya Anavati Khata for alienation in favor of Commerce and Transport Department, Government of Odisha for construction of a bus stand. Stop. The said proposal made by Tahsildar was an order passed on 13/6/2022 by Tahsildar was under challenge in WPC number 19056 of 2022. Stop. The said petition came to be disposed of with following direction and observation. Paragraphs 10 and 11. Present contempt application has been filed alleging disobedience of the said order. And counsel appearing on behalf of the petitioner has submitted that the contemners were directed to complete alienation in respect of 36 decimal of land in plot number 3341 recorded in Sabik Khata number 49 and ensure access for communal user. Stop. Till date, the alienation has not been completed. Stop. Counsel appearing on behalf of the 10, 11, 12 तक लिखो। वो 13 को वो ये कर 13 को highlight. Stop. Next. Court. The division bench, as can be noticed from the order, violation of which has been alleged. It was clearly mentioned in paragraph 13 that till alienation and user was made in respect of Samsan of the aggregate area 1.32 acres, status quo shall be maintained in respect of existing land recorded as Smashan. Stop. Next, there is no material on record to demonstrate that the observation made in paragraph number 3 of the order of this court has not been honored. 13. 2 photographs have been brought on record on behalf of the 3 photographs. 3 photographs have been brought on record on behalf of the petitioner to convince the court that the contemners are taking steps for getting established a bus stand over the land in question. Stop. The three photographs do not in any manner indicate disobedience of this court's order as noted above. So, Mr. Samantayal and AGA has submitted that nothing is being done over the
No.
land in question
And
in violation of the order.
and you also may say miss case number 15 of 23 is pending for disposal before the collector, alienation.
For and miss case number 30 of
No, 15 of 2023, 15.
15 of 2023 is pending in this regard before the collector. Which collector?
Miller, Collector Puri.
Puri. What's wrong? In our considered view, based on the averments made in the contempt application, no case of deliberate disobedience of this court's order is made out. Contempt proceeding stands dropped. Yes.
Item 14.
May I please, your lords?
Yes, sir. My friend is not that order has been complied with and amount has been paid, Miller.
Complied with.
Sole petitioner was dead, Miller. The legal heirs of the petitioner.
Son has received the amount, Miller.
All
But-
Item 15.
15, I filed the compliance affidavit.
Complied with.
Orders item 16.
Yes.
Notice question of condemnation of details, though issued, but it has returned with the postal endorsement.
So you have to file substitution application. How much time do you want?
1 week time.
You found out a death certificate. You have the address and everything. You can do it within 1 week.
Yes, ma'am. That is already there in the slide X and Y. Death
Yes.
certificate and legal heir certificate filed by the counsel for the respondent.
You need 1 week time.
So 1 week time. Next steps for something.
Mr. Saswat Das, learned additional government advocate, prays for 1 week time to take steps for substitution of the sole respondent. And I we write it in the rate appeal. Full stop. List the case. List the case on it's 9 on 22/7/2024. Interim order passed earlier. Interim order passed earlier to continue.
Item 17.
17, I am for the respondent. 10 days more time to file objection to the limitation.
What is the limitation?
517 days.
Right.
IA 160/2023.
58 days.
Dispense with, sorry?
58 days. From the date of order, it's 517 days. But as per the so moto proceedings taken by the Supreme Court, it is 258.
That is right.
IA for dispensing with all over the IA 161 of 2023. You are Mr. Biswal?
Yes, ma'am.
Mr. Biswal, learned counsel appearing on behalf of the respondent slash sole respondent or the other?
Sole
Respondent slash opposite party granted one more week for filing objection to the IA to the application for condemnation of delay. List the case on 16. List the case on 16/7/2024.
Item 18.
Also, the steps for substitution is going to be taken well.
Same order as 16.
There the death certificate was available.
So you want more time?
Here,
How much?
more time, maybe 2 weeks time.
So that also we have granted 2 weeks.
What?
So the 2 weeks time is granted. खाली कर दो. So 1 week है ना 2 weeks. 2 weeks कर दो. List on 23 कर दो.
Item 19.
Is there any interim order in 18? No interim order.
No interest.
Item delivered.
This is with respect to that Sarat Chandra Parida case. That case is
So when is that date?
8th July.
8 July thila. So I would date habo. So that was 16 July, then there is no court. Another date of the pixel, we can keep it for another day along with the connected cases. Office note.
Though in those cases, a limitation must have been condoned.
Not all.
Not all. All right.
some cases limitation has been controlled. Here the limitation, on question of limitation, notice has been issued, but nobody has entered appearance.
The dispensing with all over there. Item 19. All right. Office note indicates that item has that the notice has been served on this sole respondent. List the case on what date should we fix? 22nd?
16th.
No, 16th is 1 week, but since a lot of matters. 23rd. List the case on 7/2024, along with the connected cases. Registry is directed to verify if any counsel has appeared on behalf of the respondent and indicate the name of the counsel and the cause list.
Item number 20.
Also same, my lord, but here no notice has been issued on the question of limitation. There is a delay of 109 days.
Dispensing with further. This I has been filed for condemnation of delay of how many days?
109 days.
109 days in filing of the appeal. Issue notice. Item 20.
833.
It has been issued. Noting is confusing. This is not the way they should note.
Not by
40. 832. Where is it? What is this? Issue notice. They're not putting up the proper note. It has been noticed since 21/5/2024. The office note is misleading. The perusal of the order dated 21/5/2024 reveals that notice has been issued on the question of limitation. But on account of non-filing of requisites, notice could not be issued. Mr. Das, notice could not be issued. Your notice has been issued, you have not filed requisites. Office note is misleading, that is why you could not.
That item 22.
Item 20. The office note is misleading, but actually notice has been issued, so your order sheet should reflect that 21/5/2024. IA 2127. So you have to file requisites. Do it by Friday.
By Friday.
Mr. Saswat Das, learned additional government advocate, undertakes to file requisites by Friday. If requisites are Friday 12/7/2024, requisites are filed as undertaken, notice shall be issued fixing. Notice shall be issued as per order dated whatever line of it. All right. No, 21st May. So what returnable date is not. Okay, let us fix the date. Notice shall be issued fixing a returnable date within 6 weeks. This is the case of 48. 48/8/2022. 24, sorry. 24.
Item 21.
From 21, the Lordship may see the order dated 29th 11/2023. 29/11/2000. This case was dismissed for default. Thereafter, I think no restoration petition has been filed. It was dismissed for non-prosecution.
Let me examine that.
Order dated 29/11/2023. Your Lordship may see that.
23 matter notice. This is matter 23.
29/11/2023.
Yes,
So I'll let me examine that. Not within my.
It is already dismissed.
but this office note, what is happening? I cannot, there's no office note.
There is no office note in the lease. That it is. That is what I
has been restored.
Office note indicate, that one, then we have to see. Restored by what? You filed a CMPL?
Yes,
No. Highly. No, order, the copy has not been.
All right, solve it up.
Just a minute.
That is also not noted in the list.
I'll check out. I'll instruct my associate to you.
Registration highly.
नहीं,
That has.
What is? अच्छी देख ले CMPL allowed. Office note का है? Yes.
870/2.
Yes, Mr.
Yes,
Bharti, you are wrong.
Copy
CMPL
is
there,
not
that is disposed of. That means it's restored.
already restored.
Disposed of fellow कौन होगा? Considering the grounds taken, order dated so and so is recalled
Oh, sorry. Then it's
on 20th June.
20th June,
Huh?
24. Yes.
This is the case next week.
Yes, next. 1 week.
This is the case on 6. This is the case on 23/7/2024 as prayed for by Mr. D.K. Mahanti, learned additional government advocate on behalf of the appellant.
All right.
Appellant.
Like-
I'm not the
Sorry, I'm
appellant.
sorry.
I'm for
On behalf of the respondent, how many respondents?
How will it respond?
I think all the response.
All the rest.
On behalf of
All
the
the-
respondent, yes.
26.
Item 22.
Petitioner will let you know, Mr. KP, Mr. Ponda is there or he's not there?
But he's there.
You are Mr. Ponda?
The associate.
Exactly, I was thinking that, what is your name, please? Ki Mishra? Rajiv Mishra, okay.
Item 22.
22, my lord, let me.
Incomplete filing of requisites.
No, respondent number 1, requisites was filed.
Yes,
Respondent number 2 is the pro forma respondent.
okay.
So today also we have furnished the requisites. Today we have furnished.
The performer you want to take or don't want to take?
Already requisites filed today.
All right. Mr. Sasodat, learned additional government advocate submits that requisites for issue of notice on the question of limitation.
Yes, ma'am.
On the question of limitation have on respondent number 2.
1 already gone.
Yes,
2 today filed.
on respondent number 2 have already been filed. List on. A notice may be issued as per order dated. देखिए तब पुराना order था.
14/5/24.
14/5/2024. Is the case, what the date?
6 weeks. Okay.
20th August.
Item number 23.
Item 23, I have taken respondent, I have filed
I have filed an objection to the IN number 5059. That has not been brought into record. Lordship shall kindly adjourn the matter and along with to brought the record to my objection. It's
What the relay?
That I am appellant.
What is the relay?
Matter relates to.
Delay.
131 days.
You want the relay?
that is Lordship shall kind some other day because I have filed to Lordship direction. I have filed the objection to the IA. Some other day Lordship shall.
Similar matter is also.
And it has not been brought into record.
Yes. My lord's judgment. that matter relating to promotion during the pendency of departmental vigilance case.
Criminal case.
Yes, criminal case. Two matters I am giving my lords.
No, but let that come.
Yes.
His objection.
Mr. Pierre Chatoil and counsel appearing on behalf of the appellant submits
Respondent,
that,
respondent.
sorry, on behalf of the respondent submits that he has filed an objection to the interim application for condonation of delay. When?
Today itself.
Today you have filed?
Yes.
Today. This is the case on 11/7/2024 along with the said objection. You served copy?
But they did not accept because they did not give the receipt. I am just now serving.
They did not accept.
Notice, receipt was not given. That's why it could not serve in the office.
Anyway, he serves copy of the same on Mr. M.K. Khuntia, learned additional government advocate appearing on behalf of the appellant.
Item number 24.
For the orders. The notice sufficient है कि देख ले?
Lordship, on behalf of my learned senior Mr. Milan Kanungo, Lordship is out of station. I pray for Lordship to kindly take up the matter next week.
Please wait. Is anybody appearing on behalf of the respondent? Item 24. No. Notice sufficient है कि देख ले? के पे date के पे returnable date. Name please.
Bismay Rai.
Your name.
Bismay Rai.
Mr. Rai, learned counsel appearing on behalf of the appellant, raised for adjournment. Office nahi. Notice has been served on notice served है जी कोई जल्दी. AD has come back. Notice is sufficient on the sole respondent as returnable date was fixed to 4th July 2024. This is the case on 16/7/2024. Registry to verify if any counsel has appeared on behalf of the respondent and indicate the name in the cause list. Yes.
Item 25.
Grateful.
At 25, notice has been issued on the question of limitation. Last occasion, your lordship had
No counsel has appeared already. Delay, how much delay?
delay of 495 days.
Notice is sufficient. We granted one chance, register to verify if counsel has appeared. Nobody has appeared.
What is the explanation?
Right.
Or what is the matter about?
The matter regarding regularization, and this has been disputed on the very first day without giving us an opportunity to file a counter, because without taking into account our circulars issued from time to time regarding regularization, Honorable Court has directed for regularization of his service. That our circular says 3 circulars, 1 before post Umadevi, there is a circular regarding regularization. That those who have continued after.
This is item 25.
Some cost. Which IA is for limitation? Donation?
388 of 2024.
And 387? Hello? The other
387
one?
has been
Let see as one for
Oh,
dispensing with 388 for condonation of debt.
IA number 388 of 2024. There is delay of 495 days in filing the present intra-court appeal. The state of Odisha has put to challenge an order passed by a single judge of this court dated 38/2022 in WTC number 21136 of 2022, whereby the single judge has directed the state to regularize the services of the petitioner within 3 months from the date of passing of the order. Stop. The said writ petition was filed on, presented on 17/10/2022 and
Yes, record as 1710. No man.
Not 25. Filed on 17/8/2022.
filed on 17/8/2022 21136. Bhaktavandhu Sahu.
Yes,
Yes, ma'am.
yes.
Filed on 17/8/2022 and was placed for admission on 30/8/2022 for the first time when the impugned order was passed. Directing regularization of service of the respondent. Apparently, the appellants did not have any occasion to file any counter affidavit. Full stop. Next. Though the explanation put forth in the application seeking condonation of delay is not very satisfactory, we deem it proper to exercise our discretion by condoning the delay upon payment of cost, in the interest of justice, since the order impugned was passed on the very same day when the matter was listed and within a week of filing of the writ petition. Accordingly, this application is despite service of notice. Notices have been sent. Service of notice, the respondent has not entered appearance. Accordingly, this application is allowed, subject to payment of cost of rupees 10,000 by the estate in the account of the Orissa High Court.
What is that welfare fund?
High Court, Your Lordship, High Court Welfare.
High Court Bar Association?
High Court Bar
Advocates-
Association, High Court Bar Association Welfare Fund.
Advocates Welfare Fund, what is the exact thing?
But
Pachari koi debe.
three funds are there, most any fund, you also High Court Bar Association fund is also welfare fund, you also.
High Court Bar Association Advocates Welfare Fund.
Within 3 weeks, 3 weeks.
Well, Your Lordship may say 4 weeks, within that we
4
will file
weeks.
for time.
4 weeks. We'll discuss matter on 5 weeks plus admission within first 5 cases. So whether any comprehensive judgment is there on this point?
My lord, so far as this regularization is concerned.
No, regularization is one part. On the point that the writ petitions should not be decided on the first day. Whether there is any decision of this court. The other aspect we will take care of, but whether
Yes,
this
Malay.
aspect has been,
I'll search, my lord, and I'll.
because if we do not agree with the view taken by the learned single judge, and if we are of the view that a positive direction cannot be given without giving an opportunity to the other side, then we may have to lay down a law.
Yes, ma'am. My lord.
So whether this aspect has been dealt with or not.
So, my lord,
Some
in
matters
number
have
of,
been remanded.
yes,
but-
my number of writ appeals that has been remanded, that's on the same ground that we have not been provided opportunity.
Show them.
I'll give
I
that.
think Chief Justice Muralidhar's
Yes,
or some
Three
orders are there.
judgments, 3 judgments are there, that in one judgment, 800 writ appeals are there. All those cases relating to pension of block grant employees, those are decided on the very first day, even with a positive direction
Give
to
those.
give them pension. So
give
those
them.
pension,
Give those numbers.
I'll give that judgment, my lords.
Date kya hoga na?
In those cases, on the limited question that as the state were not given opportunity to have a say, and that taking into account the principle of natural that has been remanded, I will give that judgment.
Yes, within first 5 cases. Oh, first तो पहले आएगा. Oh, first, ठीक है. Within first 5 cases.
Yes, Mr. Dale, what are you?
All cases, consent of head counsel are there, Lordship.
No question of consent.
That is
If-
the
if-
personal belonging, so they will give consent.
No, Lordship, who variety of judgments are there?
So you give other variety you give.
Justice, Honorable Justice, moral judgment there, Lordship, so far the reasonable oppositional hearing are not there. But in other cases, this division of the whole Lordship, because they have given consent.
All right, you give
Mr.
that.
You give that, the principle is
Lordship,
that if you are asking someone to consider something,
Lordship.
then the matter is different. But if you are on the very first day directing someone to do that,
Lordship.
possibly that cannot be done.
That's got about, in
So-
a covered matter, Lordship.
Covered matter,
Because that the judgment is.
even if it is a covered matter, they may be directed to consider in view of that. But
Yes.
then they may not be directed to do it in view of the covered.
That's-
What stand the other side will take, and then particularly when the state is the opposite party. So when the state loses, it is not that Mr. Khutia loses.
State loses, but Lordship.
State loses means everyone loses. You also, everyone.
But our concept, Lordship, one litigant gets justice.
Yes,
if
yes.
the Lordship.
Yes,
the
that we
state's
understand.
interest, Lordship.
Once
That-
litigant gets an order, that is justice.
Lordship, it states in this lordship because he
Yes, so and we have to
You
balance
give
everything.
that.
I'll give that
We
judgment
need
even
to
if
balance
one case.
everything.
Item number 26.
May I plead your lordship? My lord, I am for the respondent. On last occasion, my lord has ordered the government to serve the copy, but the copy has not served it.
Last occasion, Mr. Sanat Kumar Das, he entered appearance for the respondent, gave his mobile number to me.
Give it to
Sir,
madam just now.
I'll give it today. In course of the day, I'll serve.
Give his mobile number and then did not pick up.
No, he picked up and said, I'll.
All right,
have
all
no
right.
issue." So that is why I'll serve on my learned friend.
Madam, what is your name?
Yogomaya Biswal.
Sorry?
Yogomaya Biswal.
Jogomaya.
Yes.
So you're supposed to give copy of limitation petition. Acha. On the last date, item 26, na?
26.
Detail is it only?
2724.
27?
Madam.
Acha.
2724.
Acha. Mr. Saswat Das, learned additional government advocate, submits that as Mr. Sanat Kumar Das was not available on the last date, a copy of the IA, a copy of the interim application for condonation of delay, nor the appeal memo could be served on him. Full stop. Today, Ms. Jogomaya Biswal,
Yogomaya Biswal.
learned counsel, appears on behalf of Mr. Sanat Kumar Das, learned counsel for the respondent. Learned counsel who has appeared for the respondent. Copy of the IA for condonation of delay as well as the writ appeal are served on her in court today.
In course of the day.
In course of the day.
Madam.
You don't have it just now.
Just now I don't.
Again,
Just
same
now.
problem you'll face.
No, today I'll serve.
Assures that the copy will be served on her in course of the day.
In course of. Madam, within 10 minutes. Within.
I can't write within 10 minutes. If you serve, I could have said you have served. List the case on. List the case on 23/7/2024.
Let's serve.
Obliged.
Copy served.
Add order, Rajyotila, please keep that. List the case on 16/7/2024.
Madam, may indicate copy served.
Yes, yes, that order, early order stands.
Item 27.
Here, the delay of 40 days, there is a technical delay because writ appeal was filed on time, but they have filed the Xerox copy. That is the reason why when the certified copy was filed, there is a delay of 40 days.
Xerox
My
copy
learned friend
of the judgment.
Judgment of the improved judgment. My learned friend has already appeared. And this is a case also, Lordship will see, the Honorable Single Judge has given a positive direction on the first day itself. And without giving us the opportunity, because the petitioner.
It is not positive direction, it is direction to consider.
No, my lord, your lordship kindly see positive direction. That's what I was thinking. But your lordship, after that, their lordship kindly see. My lord, they are after them. Because lordship kindly see. To consider cases of them and to grant them wages. That is the positive direction. Not for consider for grant them wages are directed by the Honorable Supreme Court. And the Honorable Supreme Court judgment, my lord, those two judgments are not absolute, not applicable in this case. And the petitioner claims himself to be daily wage, but he has not filed a single document to show that he is a daily wage employee. And we have made our stand clear in the writ appeal that had we got the opportunity to file counter, would have said that he was not our employee at all, he was not working at all. That's the reason. There is a positive direction, otherwise I would not have advised them to file a writ appeal.
Yes.
40 days.
40 days delay we are condoning.
My learned friend is the first respondent.
Yes, admission.
I'm responding to all the cases, three appeals. And I have no objection for the conversation of delay.
You'll see at the time of admission.
I have also received the copies.
You have received copy of the appeal memo?
Yes.
IA for condemnation of delay. There is a delay, everything 40 days?
Yes, all the cases.
ତାହେଲେ ଗୋଟେ ଗୋଟେ ଯୋଉଟା ହବ ସେଟା କରିଦେବେ IA for condemnation of delay. This application has been filed for condoning the delay of 40 days and filing the writ appeal. It has been stated in the application that though the writ appeal was filed within time on account of non-filing of
Only
this.
the last case little bit more.
Check
There was some of the little bit more.
देखिए on account of non-filing of the certified copy along with the writ appeal, the stamp reporter has pointed out the aforesaid delay. Mr. Surendranath Pandal, learned counsel who has appeared on behalf of the appellant, does not have any serious objection for condonation of the delay. Considering the
But that is only 1 day extra, 41 days.
considering the grounds taken in the IA for condonation of delay, we are satisfied that a case is made out for condoning the delay in filing the writ appeal. The application is the delay is condoned. The application is allowed. The interim application is allowed and disposed of. List the writ appeal likhive. List the case 16th or 1 week or more. List the case on 16/7/2024 for fresh admission. The copy of the writ appeal has already been served on Mr. Pandal, learned counsel appearing on behalf of the appellant.
Respondent.
Sorry, respondent. ঠিক আছে 16/7. Oh, you want further time?
Because my application was staged there, that is the reason why shorter date may.
1 week? You want
16 is okay.
16/7 is fine.
Much obliged.
Last 41 days for you.
Item 28.
May I please? Lordship, there is a delay of 39 days. Respondent number 4 is on caveat and I have already served copy. Respondent number 1 and 2 are state, I have also served copy on them.
Mr. Lakshmikant Manti.
Madam,
You're there.
I am for the respondent on behalf of Mr. Lakshmikant.
Yes. So what is your objection to the call?
No objection.
You have no objection. What is your name?
Rasmita Das.
Rashmita Das. IA for condemnation. लिखित हुए Mr. Aditya Mishra और side लिखित हुए Ms. Rashmita Das. This IA has been filed for condemnation of delay of 39 days in filing the appeal. What is the ground taken?
Lordship, there has been a change of counsel and in the month of February and March, usually examination were continuing in the college. Appellant here is a college. So for that collection of the records as well as exam duties and all, there is a delay of 38 days.
This is IA 1859.
185.
Okay. Mr. Mishra, learned counsel for the appellant, has stated that on account of the reasons for filing the appeal beyond the period of limitation have been explained in paragraph 2 and 3 of the IA. We are Ms. Das, learned counsel appearing on behalf of the respondent.
No, my lord. Respondent 3 and 4, I am for 1 and 2.
Who you are for 1 and 2?
I am for 1 and 2.
On behalf of 1 and 2 is state.
State.
On behalf of respondent 3 and 4, does not have any serious objection to the.
For respondent number 4.
4 only.
3 case. Who's there for 3?
3, no one has appeared.
Who is 3?
And 3 was also not appearing in the writ petition.
Just a minute. We have to see if notice is sufficient or not.
No, Lordship, notice has not gone.
issued. Notice has not issued.
She has appeared suo moto.
Yes, by caveat.
Respondent 4 has,
Does not have any.
No, he has not appeared in the tribunal, people on single judge also.
the order is in
Not
favor of respondent.
CK college.
No, another employee.
appearing on behalf of the contesting respondent. Contesting respondent, hyphen the respondent number 4 does not have any serious objection to the prayer for condonation of delay in view of the short period, full stop, short period of delay. In the interest of justice and after hearing learned counsel for the respondents, we are satisfied that this is a fit case for condoning the delay of 39 days in filing the appeal. The delay is condoned and the IA is allowed and disposed of. Writ appeal.
Notice will go to respondent number 3, Your Lordship. As because
You received copy of the appeal memo? Kaku kujibo. Our respondent 1 and 2 pe right Mr. N.K. Khuntia appears. Learned additional government counsel appears for respondent 1 and 2. No, we'll issue notice straight away. List for fresh admission. They will appear one person. Respondent 3. Respondent 3.
3, though he was not appearing still then, as because
Respondent number 3 here, my lord.
List the case for 16/7/2024 fresh admission. Let us do it that way.
Item 29.
Again, somebody has appeared. Yes. How many days delay?
That 906 days delay, but your lordship can see, my lord, the state appellant is acting like my lord, the appellate authority of this honorable court. And when your lordship passed the categorical order, I had order dated 21/5/2024. Lordship kindly have a glance. My lord, after that order, my lord, they have rejected my case. Lordship can see order dated 21/5/2024.
They were asked to consider, so they've considered and rejected.
No, your lordship's order in irritable, my lord.
Oh, okay.
My lord.
Which order?
Order dated 21/5/2024.
This is where I was seeing.
Lordship can see last 3 paragraphs.
This is the case.
Lordship.
Also imitated. Second.
Made. Time for the appellant. I'll satisfy my lord. I'm giving a short, that's the last of my lord's pen. Your lordship, there is a date, my lord, 16/9/2021. First to last 16/9/2021.
Yeah.
Thereby, this honorable court disposed of the writ petition directing to give him promotion from the date when his juniors has been promoted. Here, your lordship pay that order at page 13.
Which order?
Order of the honorable single judge.
Yes.
Page 13. My writ appeal.
Page. Yes.
Page 12 starts from 12.
Yes.
Your lordship, page 13. It is keeping in this view, this court in disposal of the writ petition directs the principal secretary to Government of Odisha Finance Department of Bhubaneswar to give promotion to the petitioner to the rank of POTAS from 7/2/2014 and OFS 1 from 5/1/2021 from the date of his juniors and batchmates got such promotion. However, the promotion as per direct shall be subject to ultimate result of the freelance proceeding. Then you'll also turn to my date chart.
Yes. Your lordship, from my next plate. 24/3/2023.
Yes.
He was acquitted in the vigilance case. Then on 7/12/2023. In the departmental proceeding, he was imposed with the punishment of censure. That is a minor punishment. There is no bar for promotion.
Then why will you not grant him?
Yes, I am coming. Then, my lordship, 31/1/2024.
Yes.
You granted.
Was promoted with effect from 1/1/2018. His claim from 2014.
Why have you selected
Juniors
that?
are
From the-
promoted from 2014.
Yes, ma'am. The admitted fact, junior is promoted from 2014, but his case, why his case has not been considered. He was appointed in year 2010 by virtue of my lord's direction in another case. So he has not completed that residuary period of 5 years when his junior, admitted fact, his junior has been promoted in 2014. It is admitted fact he has got from appointment by virtue of my lord's order. He was appointed in 2010, but the first selection was made in the year 2003. They were appointed in the year 2005. As he was appointed in 2010, as appointed against the vacancies of 2003, was placed above his juniors on the basis of merit list.
No, but why should we go into all these details?
This is the fact for which.
My lord, interestingly, your lordship kindly have a glance. My lord, the affidavit I have filed.
Oh, that is why you challenged the order
That's why we have challenged that order.
after so long.
Lordship kindly see affidavit, my lord. Flag F, my lord.
Oh, when was the
Is that order here where he was given appointment, this order of the of this court in the earlier writ application, is
Yes,
that here
that he has filed it.
I have
the affidavit.
in your affidavit?
Yes, ma'am.
Flag F. Flag F, lordship
Flag
kindly see
F
page 9.
13017. Writ application.
That is the affidavit dated, my lord, 17, yes. And lordship kindly have a glance to page 9.
Affidavit filed on 1st July 2024.
Yes, order in.
no, but why are you referring to this?
I am not referring. I am not, because why I am referring to, because he was not completed 4 years as in 2014. He was not promoted to the task.
Why was he not promoted?
Has not completed 4 years that residency period of.
Why?
Because he was not appointed. That I understand. My only because of this we have, because after acquittal we have promoted him. Everything is. After acquittal and after completion of the departmental proceeding, there is no bar for his promotion. That is the admitted fact. I am not disputing.
Only thing is that he cannot be given promotion with effect from a date when he was not qualified.
Yes, that's why we have approached my lord.
Under the rule.
Yes, ma'am. But admitted fact, he has given appointment against the vacancy of 2003. There is no dispute about it.
But at least he should be given promotion with effect from the date when he attained 5 years or something. I mean,
May I pray with that observation, if your lordship will dispose of with that observation?
Lord, the vindictiveness of the state appellant, your lordship can
If
see.
my lord
Yes,
observes.
yes. And they provide.
see,
Yes.
you are claiming your promotion with effect from 7/2/2014.
My lord, when my junior got promotion.
Your junior got promotion, but you had not completed 5 years.
That, my lord, your lordship kindly have a glance to page 37 of that affidavit, my lord. When my lord, the finance department, your lordship kindly see page 37. There, I am reading out, my lord.
Wait. Page 37.
Of that affidavit 17/2024.
So
No, when were you appointed?
In the year 2010, my lord.
Give us the date.
My lord.
That I have given in my date chart, my lord. Your lordship, 23/8 in my
You
date.
were appointed on 23/8/2010.
My lord.
How can you be treated to have been appointed from a date prior to this?
My lord, because my lord, I am a recruit of the year 2003, my lord, and a pursuant to lordship direction, they, my lord, the Odisha Staff Selection Commission, my lord, placed me in the year merit list in the year 2003, my lord. And pursuant that, my lord, the government file a review was dismissed, and they gave me appointment on
All right.
16.
All right,
Yes, my lord.
we can go one step ahead.
My lord.
Is there any, see, we are bound by the rules.
My lord.
All right, if the rules provide, we cannot deviate from that.
My lord.
We cannot say that we just ignore it. Is there any provision for relaxation? Is there any provision for relaxation under the rules? You are required to complete 5 years. You did not complete. Maybe for any reason.
And that too, my lord, the government, yes.
Is there any provision under
Yes,
the rules?
there is a relaxation of, yeah, Lord, so for some time I am coming back, that rule is in my chamber, my lord,
All right, we will take up only thing which we can do is that instead of what they have done from 2018, we can direct for granting you this promotion from the date when you attain 5 years.
Yes, 2015, they kept it in a seal cover.
Yes.
And
so
did not
2000
be satisfied with that figure. It should be satisfied with that.
All right,
yes.
that we can do.
And they gave national promotion, and now, my lord, they are saying that you are not entitled. That is what I am showing, my lord. Page 37 of that, my lord, affidavit. Lord, kindly see page
No,
37.
how can you overcome that situation when you could not complete 5 years for any reason? How can you be given promotion?
I am given.
So we can do that
Passover, I am giving that.
tomorrow.
My
Tomorrow.
Item number 30.
Please, your lordships. This is the case of a lady.
Can
Age
you wait for
about
some time?
67 years, my lord.
Please wait 2 minutes.
His son was implicated as a party and he was noticed.
Disposed of, saying that release within 3 weeks. That the nominee is dead. Because they filed that certificate also saying that the person in the meanwhile died. So court response of saying that release within 3 weeks. Thereafter, the bank comes up with you came up with an IA?
Yeah, I have filed a review application.
Not review, there is an IA. There is an IA.
IA they have filed. I have filed a review application. In that review application, that was allowed.
Yes, sorry. A review petition was filed. Which
Yes.
was notice to the petitioner that has been disposed
Yes.
of modifying the
Yes,
order.
madam. And also to the notice to the legal heir. Legal heir was noticed. The nominee was noticed.
That in the review
Please wait.
petition.
Were you
Not speak as
were you heard in the review?
No, no,
Yes.
my client does not
Yes,
know.
you are there.
My client does
That
not
is the
know.
order. That is the order.
It is not there because subsequent order says that he was not heard.
No,
What
no.
is the order in your
No,
review
no.
petition?
Your lordships may kindly see,
Yes.
because he has not given me the
Yes,
copy.
yes, yes, yes.
Which order he has
No,
challenged.
no, forget that. You
Yes.
tell me what is the order in your review?
Order was after hearing Mr. Nayak and Mr. Mishra,
Where is the order?
your lordships
See.
may kindly see review application number
3/11/2022 order.
yes, yes,
Yes, where is it?
213.
213.
113.
Your
he has not
lordships, I am
appeared.
passing it on.
Yes, pass the order. So the subsequent order is passed that he has not been heard.
No, that day he was not present. Your
See.
lordship may kindly see the review order. I am passing it on.
Yes.
He was heard. In his presence, the review was allowed, and also the court felt that the nominee should be made a party and he should be noticed.
Okay. So you had appeared. I was wrong. You had appeared.
I had appeared before the court.
Yes.
From my side, but client must get the notice.
No, no,
Because
no.
it's a review
It's
petition.
all right. It's all right. You appeared and you wanted to add the nephew as the respondent. So the order was modified to this extent. I was under the impression you were not noticed. All right. So to this extent. That the nominee be added as respondent. So reviewers to that extent that
Yes,
will
yes.
be added.
Only for that action only. And thereafter, after getting notice, the nominee appeared and he filed a petition before the honorable court. And the honorable court, after hearing both sides, passed an order.
No, hearing outside, but this order, the earlier order has not been modified. Only thing nephew has been added.
Yes.
But that to release that proceeds, that order still stands.
No. That previous order, this
Addition of party to the writ petition can be on recall of order dated 29 July 2022. However, the order stands carried out in respect of 2 of the 3 accounts. In the circumstances, order dated 29 so and so is modified to be in respect of 2 accounts or money in which already has been disposed to, so confined to two accounts. And thereafter, then another order.
when different orders are passed, I'm showing to a lordship's my lord.
Then 18/2/2023.
The order,
The nephew was added as opposite party.
29/7/2022, my lord.
That is the original disposal.
Yes. Yes, that original disposal,
Yeah, that is over.
that is over.
2022 is the review order where the opposite party, the nominee was added.
Yes.
Yes. Thereafter, on 8/2/2023, the nominee has been added.
Yes.
Yes.
And always Mr. Nayak was also heard.
And that was disposed of relying on that AIR 1984 Supreme Court
Yes,
decision
84 Supreme Court,
346.
that the nominee is entitled to receive the money, but he is not entitled to take the money.
Yes.
That's why the honorable court said that he is entitled to take the money. And he filed a petition, he has to say all these things because
Not
I will
entitled
not
to
say
take the
all
money,
those
he
things.
is only entitled as,
Because,
Manager is in service.
pardon, my lord?
Manager is still in service, the chief bank manager. The
My lord?
bank manager is still working.
Yes.
He is working, he is in bank
No,
service.
no, previous manager transferred, new manager has come.
He is in bank service now.
Yeah. And last.
All right, how this is to be resolved? Have you? Huh?
So they are a childless couple. So
Matter is somehow different.
no money, no money.
The last two orders.
No. There was no nominee, that she got.
Lady God.
Lady got.
His client. Give.
Pardon, my lord?
How will you give the money?
Already we have asked for, my lord, kindly see this order. This is the last orders passed by this honorable court. These are the two last orders. These are the two last orders. Peruse, these last two orders I have passed.
Who are you?
These last two orders, the honorable
Respondent
judge.
number 2, nominee alert.
Nominee has no right.
But here, your lordship, last more than 25 years, she has left her husband.
Maybe.
And during her last time, 6 years, he was bedridden. I have taken.
Must be
That is
possible.
all right. You have bedridden, you also must have spent his money also, looking after him,
We have
everything.
informed she has not.
Sorry? It is not necessary. Because bank account, you don't have any right. That is the problem.
What is the amount total?
If he has given you any money, that is different.
What is the total
And
amount?
the matter.
Total amount is.
Request of my senior matter was settled amicably.
Because he doesn't know. Due to his fault, the client should not suffer.
And the total amount is 9 lakhs. 9,62,786.
Give her. The
We have
entire
already processed as per the direction, interim direction of this honorable court. We have processed the thing, but I have instructed them to solve the matter because there was no final order. And time to time it was modified by their interim application.
No modification. You do it and tell us. You give her the money.
Yes.
We'll monitor it.
We'll immediately comply with your lordship's order.
What?
If your lordship order pass, because there was I have passed two documents, there was 2 orders modifying the orders. Honorable Justice Shila passed 2 modified orders.
Don't name, please. This is not the way.
No, I know.
Mischief of your bank. You have been negligent in filing that affidavit. Had that not been done, all these problems would not have arisen. How can they be so casual coming to the High Court and giving an affidavit?
No.
And you say that he informed over WhatsApp?
Actually, my lord, candidly, I am confessing.
Don't say those actual
No, it is my fault because.
Don't say all
Because I have
those things.
overlooked taking the complicated
It's all right.
litigations before that. That's why I have said in
You have
court.
overlooked when he is filing an affidavit, he is not supposed to overlook. He is a responsible
That's
officer.
right. That
not
I
an
oblige,
illiterate
ma'am.
person.
But that's why I have filed the review application. And review application was allowed that the errors will be rectified, man. 2 orders I have passed it on honorable judge's order, man.
You are neglecting in paying the money.
Mr. Naik, what have you filed this writ appeal for? For disposal of your IA?
My lord,
So please wait.
His IA is pending. If the IA is pending, that's why writ application for disposal of the IA.
Mister, you are making mockery of everything.
My lord, the petitioner,
Are you doing drama in the courtroom?
man, the petitioner is a old lady about 67 years.
She is old lady. What about you?
My lord, sir, I am insisting the court to disperse the money. But the court are going on neglecting it, and the old lady lastly.
Please.
Every party, the bank is irresponsible. He is greedy.
No, bank not creating.
Bank is irresponsible for filing that defective affidavit.
Nephew is greedy and he does not know what to do and what can be done.
No, your lord, never a single day he approach the nominee, your
It is
lordship.
the procedure
Why
that
should
the
she
nominee,
approach you?
my lord, it is the procedure that the nominee and the legal heir both will sign so that we can disburse the money. They are not coming up in spite of several orders of this honorable court. As a result, they are going on filing IAs and before this honorable court. That is the problem, my lord.
That is not the problem.
No, problem for the bank to disburse the money.
No, the problem is that the bank has officers like you.
No, my lord, your lordship may kindly say what steps you have taken.
We can tell you what can happen. By a judicial order, a disciplinary proceeding shall be initiated against the officer who had filed the affidavit. And the entire problem began because of the filing of a false affidavit.
We don't want to modify the other thing.
Where is the question of modification? Such irresponsible officers are there in the bank.
No.
Which bank is this?
No, man. I'm not standing on the.
No, sorry. Which bank is this? State Bank of India? Let the Chief Manager, State Bank of India, file a comprehensive counter affidavit. India, which place? Who is the head of Puri, Bhubaneswar?
That is in branch manager.
Branch manager is nothing. Branch manager shall be dismissed. Who heads the state bank here in Bhubaneswar, Odisha?
That is in the regional manager. Sambalpur is the authority.
Let regional manager Sambalpur be implemented. We considering the peculiar facts and circumstances of the case, despite the fact that we are of the prima facie view that this writ appeal is not maintainable, considering the nature of the dispute, we direct the regional manager. What is it?
Sambalpur, manager. Sambalpur.
There must be someone above him. Who is his disciplinary authority?
His boss is regional manager.
No.
Who is the controlling?
Who is above him?
Affidavit was filed by whom?
By the branch manager, senior branch manager.
Who can dismiss him? Who? Which officer can dismiss him? Who is his disciplinary authority?
Disciplinary authority, general manager, madam.
General manager what?
General manager of State Bank of India.
Bhubaneswar?
In charge of Sambalpur.
He or the in Bhubaneswar, who's chair of the.
There are zones. Sambalpur zone. There is a Sambalpur zone.
Zonal manager, State Bank of India, Sambalpur zone. File an exhaustive affidavit dealing with the case of the appellant emerging from the case of the appellant in respect of what are the account numbers? What is the account number?
Account number.
Pardon,
Account number.
Account number is
In which he is the nominee.
1080-394-3664.
Could you, during recess, please give that account
Bank
number?
account number.
It shall be required.
There, ma'am.
He shall be
Correct
required.
designation of that officer.
He shall be
I'm
required
passing
to
your lordship mechanically.
go through
Accord.
all the pleadings on record from the stage of filing of writ petition before this court, comma, a review application and modification applications, as well as the present intra-court appeal. Stop. It will be the responsibility of land counsel representing the bank to hand over a complete set of the pleadings and various orders passed by this court. Who hand over make available to the general manager, who shall be required for him to file an affidavit pursuant to the present order. First off, this case on 2 weeks. Stop. Next.
Both there is
This one. How can you say 1-0? Rohit Meher is the nominee in the second one. You are saying 1-0, it is
there are
318.
3 accounts, my lord. 2 accounts we have already paid to him. Only 1 account is only remaining because
Which account?
Number 1 account. Account number 1. The top one.
Top one, there is no nominee.
There is nominee of.
Because you are so casual, this is the problem. Your own document, you are giving us.
So I'm
nominee
giving an affidavit
the
setting
second
the
one.
details, my lord. I will file an affidavit
Give that,
setting the
please.
detailed accounts
No,
and
no,
everything.
you give that. You just read it and then give it. Your own document and you have not gone through it. So is it first or second?
Second one.
Yes, give it, please.
Second one is become.
Date chatter devi.
Chapter body de baba. Second one.
Item number 3, password matters.
That's in fact, that officer has been detailed for the Raksasa duty since last. He is detailed for the Raksasa duty. He is still there at Puri. I've talked to the collector. He tried to contact him and send him the link of the Lordship's code so that he can appear. But I don't know whether he could get the same through mobile because he's still there on duty.
When?
When will he appear and when?
1 week.
Any day, Lordship, I can contact him next week. Lordship, next 2 days, I'll try to get it done.
16th.
Yes, ma'am.
Item number 49, fixed for 2 p.m.
Which page?
Lord, in these cases, today I have filed a petition for intervention, my lord.
Petition for intervention.
Yes, my lord. I would be the beneficiary of the end user, my lord, for whose benefit the government and the OMC has issued that guidelines of linkage. It is in order to protect the industries, those who are established in the inside the state, my lord. And
May I begin my case, my lord, if my learned friend doesn't mind? It's my petition. If your lordships don't mind, my lord, could I begin my case, my lord, and then my learned friend?
Just a minute, Mr. Yes.
So that's why.
See, this is his writ petition. He wants to argue. So should we allow him to argue?
No, your lordship should normally, but as I'm given to understand, the state has not yet filed a counter.
You're filing it during the course of the day, your lordship.
And we being the beneficiary, from whose benefit this circular is intended, the outcome of this writ application will either way affect us. That is
Maybe, but let us hear him.
all right.
We'll see.
I'm
Mr.
grateful.
Mishra, they are
I'm so
going to
grateful.
file counter affidavit. Don't you think that you should wait for that?
My lord, my only worry, I'll tell your lordship, my lord, I'm completely in your lordship's hands as always, my lord. My only worry is the, my lord, auction that takes place every month is due to take place. Now, I have been barred from the auction needlessly, my lord, completely, my lord, without any basis. I have been barred from an auction, and that is my only problem. My lord. This is a restrictive practice. How can anybody be barred from auction? Because, my lord, I am not an allottee. I am a holder of a long-term linkage. Yes, I have got no allotment. So all I am saying is, I may be permitted like everybody else, because, you know, my learned friend who's trying to intervene is saying he's an end user. I am a much bigger end user. I have, you know, a 5,000 crore plant. They have 2 plants, in fact. So therefore, all I am requesting is don't starve me either. My lord, L1 should always succeed. Your lordships have always held that, my lord, there should be ample opportunity for everybody to participate in an open auction. So don't bar me from an open auction is all I'm saying. The state policy, my lord, of saying that if you are barred from any LTL, my lord, linkage allocation, you will also be barred from an auction is a double whammy. My lord, firstly, that your lordship will decide once your lordship, because the state's counter will be important. Why, my lord? Because the minutes of the allotment committee is chaired, my lord, really by the state officials. So therefore, your lordship is, my lord, absolutely right when your lordship say.
What we can do, Mr. Mishra, is
Yes,
that we may adjourn the matter for a week. In the meanwhile, state is filing counter affidavit. It is going to be done today.
Today, your lordship.
They will do it today. You will be getting the copy of the counter affidavit. Intervention
Lord.
application, we don't know whether you have received or not.
No, I haven't, but I'll take a copy, my lord. No difficulty.
And then after 1 week, we shall consider every aspect.
The only aspect, my lord, I'm very grateful. Your lordship have already been very kind and given us very short dates in the matter, my lord. The only aspect, my lord, is I hope the state then doesn't go ahead, my lord, with an auction for this month, because then one whole month cycle goes. That's the problem. So if 1 week, my lord, normally the auction is around the 20th, 21st, 22nd of the month.
Just a minute.
If it is before the next auction, it's fine. 16, 17, if my notes are inclined to put it. Seventeenth of July, High Court just say.
No.
Huh?
More than.
17th is closed.
Your lordship, we are going to file today, your lordship. The main contention here is that the cap.
The auction will not, state doesn't conduct auction. It is the Odisha Mining Corporation who conduct auction.
I'm for the government.
I'm for the corporation. And Millard, that date has not yet been fixed. That date has not yet been fixed.
So let them stay their hands.
come on
Let them
Monday, your lordship,
stay their hands,
15th.
and your lordship will decide.
15.
As your lordship is proposing to adjourn the matter for a week, Millard, that should be done, Millard. Now, next week, Millard, that 18, 19, whatever date your lordship may fix, because 17.
No, the next week means 16th.
Yes, your lordship may fix.
Perfect. No?
18th.
That will be very kind, my lord.
16th, I have some difficulty.
My lord, 6.
All right.
18th, all right, 18th.
Yes,
18th.
18th, your lordship.
Very well, my lord.
As requested by senior counsel representing the Odisha Mines Corporation. What is it?
Yes.
Odisha Mines Corporation.
Mining.
Yes, Odisha
Mining corporation. It's mining.
Odisha Mining Corporation and the state of Odisha placed this matter on 1 week. On the 18th, to be taken up at 2 p.m. Anything?
Deeply grateful to my lords.
Intervention
Naik,
application may be.
please ensure that you serve the
We'll consider-
copy in course of the day.
Have you served copy
Yes,
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 of the intervention application on the petitioner?
everybody, state.
Okay.
Yes,
Yeah,
petitioner,
we will hear you. We'll hear that.
manufacturer,
intervention.
everybody.
File it in the registry.
Okay.
Deeply grateful to my lords, my lord. Deeply grateful.
For admission, item number 31.
Mr. Das and myself are also there, the petition number.
List of appearances, but I.
Yes, yes. Better.
Your Lordship, for item number 31.
Mr. Mishra, you are there for whom?
Petitioner.
Petitioner 3 senior counsel. I mean,
My lord, Mr.
you are assisting all 3 of them.
I am the advocate from report, my lord.
Okay.
My lord, I am doing. My lord, I'll also do that in.
Yes,
Your Lordship, item number 31.
31.
Your Lordship, for the.
you were seeking adjournment in this matter.
Your Lordship. Your Lordship, a copy of a soft copy may be allowed. Your Lordship, the matter is not been paginated. I may be allowed a soft copy, Your Lordship.
Soft copy, how can that be? You can contact the CPC.
Obliged.
You can evolve a system that whosoever wants can have soft copy.
Yes, yes. The soft copy will not require any expense also, only they have to give that pen drive, we can give them a pen drive. Madam, isn't there any urgency in the matter? It's pending since 2011.
Your Lordship, this is a transfer matter. We filed a wakalatnama in 2023 only, and the matter is not paginated. So it needs some time to paginate it, and we'll.
10 more years. How much more time?
Lordship, 2 weeks time.
The transfer matter.
Yeah, transfer is council. There's some demolition matter. Demolition has been carried out in spite of order of this court. That is what they say, right?
Yes, Your Lordship.
Yes. Next.
Obliged, Your Lordship.
Item 32.
My lord, item 32, I am in virtual mode. That's on the first occasion, in the first hour, I am praying for time. Because on the last occasion on 20th May 24, my learned friend filed a counter affidavit after I filed my written note of submission. I pray 1 week time to file a
Whenever you
result.
want. Whenever. 1 week.
10 days, only 10 days.
10 days. 2 weeks.
Obliged.
Item 33.
Your Lordship. The order I have quoted may contain verification, my lord, para 2. Which order that violated, my lord.
The order has been violated.
Yes, 23/9/2013, your Lordship.
Lordship may look at the previous order. We paid this due Lord wages. That's why Lordship wanted to dispose of the read petitions, Lordship.
Yes.
Because against the interim order, all these contempts have been filed and we paid wages not up to date, pursuant to Lordship direction.
So we'll hear the writ petition.
Read petition in the meantime, your Lordship, it is, with due respect, my lord, the
That's
read
what we
petition belongs to
said last week.
single bench, your Lordship. Because of at that time, it was division bench, therefore the order was passed by the division bench, therefore contempt lies
before Lordship. Now, in the meantime, some matters also pending before the honorable single bench, my lord. That is my just. But I want
What is the meaning of this submission?
Lordship,
What is the meaning of this submission?
I want to draw your Lordship sentence on.
No, you don't want us to hear the matter.
I am ready.
Thanks.
But the contempt application, I want to draw your Lordship's one, their affidavit, your Lordship, affidavit dated 11/8/2017, your Lordship, para 6.
Which case? 13508.
But in my contempt application,
Why
509.
contempt? We are on your main prayer. Forget contempt.
Lordship,
Forget contempt. We are hearing the main matter.
Lordship, in fact, my lord, I am ready with the original case, my lord. But the case is that they are not paying the wages, my lord. That is the interim order was
Will you get everything?
that is the difficulties my work.
There are two aspects. One, that we cannot do anything in your contempt matter or anyone's contempt matter except for punishing the guilty. All right. Now, your grievance is that there is some interim order which is not being honored. That interim order is there because the writ petition has not been heard. This writ petition was filed in 2012. Everyone should be ashamed of the fact that in 2024, the writ petition all the writ petitions are pending.
One writ petition.
So let us hear the writ petition on merit. We will look into the interlocutory order later. This 2012 writ applications, how many?
13, Lordship, 2013.
Next case.
In the meantime, one writ petition also disposed of by the court, my lord.
2013.
2013.
13, your Lordship.
Yes. So these are all 11 years old, unnecessarily pending.
It can be, Lordship, may I
let us see.
suggest, the contempt application may be separated for which the original writ petition can be disposed of by the single bench. One writ petition also.
Mr. Please don't dictate us.
No, Lordship. Sorry.
This should be done that, and this
sorry.
should be sent to a single judge, and this should be heard by the division.
Extremely sorry. But
yes.
because today I'm facing some difficulties, may next week, your Lordship.
No, sorry.
Some
We will decide.
Lordship, in original writ petition, my lord, I have challenged the annexure 1. Annexure 1, it says 8 to the writ petition, your Lordship.
Yes.
That is a comment direction, my lord. In view of the annexure 1, my lord, the
what is there in this the direction?
Annexure 1, my lord, it is clarified the present petitioner, your Lordship, was engaged as farm driver, my lord.
Where is that letter?
Engagement order was also under annexure 3, your Lordship. At page 11. By the Gram Panchayat, my lord.
So you were engaged?
Yes, my lord.
On 4/6/2010. 4/6/2010.
11, your Lordship. 30. It is 31/6/2011, your Lordship.
Annexure 3. Annexure 3 is 4/6/2010.
Document number 216.
21644.
5.
Is that the engagement letter or a certificate?
A part of this writ application has not been listed, Your Lordship.
Sorry?
This writ application has not come before Your
We are
Lordship.
looking at that annexure. So we are asking you, is it
Okay,
the?
because of the writ application,
All cases have been listed, sir.
no, the particular WPC number, I do not know, but I think WPC 21655 2013, perhaps not come.
Oh, 21655 is not listed. So who is appearing in the first case? 21644?
In all cases, he is the counsel. In all cases, he is the counsel.
But annexure is slightly changed. Therefore, I am just keeping this writ application. Your Lordship, please.
All.
Then why has it been listed with 21644 of 2013?
That is also pending.
No, contempt with.
In each case,
There must have been order, yes.
okay, in each case, contempt was filed. So batch of contempt is there, batch of writ applications are also there. And pursuant to lordship direction, we had complied, we have paid the obstructed wages.
All right.
With the understanding that shall be hard on merit.
Was there an order on 2/7/2018 to list along with WPC 21655 of 2013?
Yes.
There is an order
Yes, ma'am.
since 2/7/2018. And it was with this because noting of 12/4/17 says with 21655.
Yes, ma'am.
So how did it go out of the? Actually, record that, though it is not being shown in the list. Everywhere it is stated with. With somewhere with each office note. So 16/8/2023, somebody has crossed that out. No order of this court to dealing. Order of this court has to be dealing. Let's see. What's it in
That was there.
Match.
Yes. Then 21645 instead of that.
But again, it is 5/1/2024, 2164645. Was that matter listed anytime 2023 before the learned single judge?
In another writ application, my lord.
No, not another.
Similar matter, my lord.
1655,
No.
because it was there with this record, but somebody has delinked it. So was it listed before the honorable single judge? No, then, oh, that, you know how, then with this file. Every year they get paid their wages if a matter is special. Call for the file. Call for the file. That file is being-
Pumps are operating,
Lordship,
pumps are functional
functional. Rural for drinking water, your lordship,
everywhere.
everywhere.
No, it's not functional, but we said that these persons are not so qualified to be entered in because they are specialized persons who can handle those. And they were engaged. That was because of the interim order, we were bound to continue them. And so far as 21644 is concerned, the petitioner had resigned, but he has filed his writ application.
No, thereafter he resigned. After filing with the.
After filing, he has resigned.
No. If you also look at Annexure 3,
But Mochilata Jana is a pump driver.
she claims not she is a pump driver.
It is a petitioner in this.
She is a female pump driver.
Female pump.
Very good. So what is the work? Switching on and off.
Switching on and off and maintaining it.
The government took a decision to engage persons who are in knowledge of all these mechanical works in place of these NMR persons because they were not required to repair the pump also.
So not knowledge, they must be having some qualification.
Yes, especially that is the
ITI or something they must be having.
ITI trained. That is the counter. Our counter is that.
No, ITI no.
Driver has a କାର୍ଯ୍ୟରେ ଯୋଗଦାନ କରିଅଛନ୍ତି.
So what do you want? What is your relief in the petition?
Relief, your lordship. I want not to disengage my lord.
Under which
Let the petition to continue. What he was let the
under
petition.
which law?
Lordship.
Under which law you should be allowed to continue?
Because earlier there were the pump drivers, my lord, in different pump houses, my lord. It was managed by RWS's department. They are completely government employees, my lord.
Please forget that. Please address us on your legal right to continue.
Therefore, I'm just bringing the case of the petition, my lord. Thereafter, when the pump houses given to the rural panchayat level, my lord, there is a decision, my lord, that in absence of the pump driver, the panchayats can engage some personnel as pump driver, my lord. In view of that, the present petitioners in different petitioner persons also, they have been engaged, my lord, prior to issuance of Annexure 1, my lord. Thereafter, Annexure 1 was issued. Government decided that in case of SCM, self-employed mechanic, they will be allowed to operate since issuance of the Annexure 1. Prior to that, my lord, this petitioner have been already engaged, my lord, as pump driver. My contention is two aspects, my lord. Once, there is a pump driver post which are lying with the government. Earlier, they were doing as there is deficiency in the pump drivers, therefore these petitions were engaged. Later on, government took a decision because these people thereafter moved to this honorable court praying for minimum wages. This honorable court also directed. Therefore, they have been paid minimum wages. Thereafter, government took a decision that no, self-employed mechanics shall be engaged as pump driver milord. They will, one hand, they will operate the pump houses. In another hand, they'll go for the well maintenance milord. That is it. In the meantime, one writ petition has already been disposed of by this honorable court by virtue of judgment, my lord, where all these aspects taken care of, my lord. But in that particular case, my lord, in similar, in the nearby the block, my lord, in that case, some period she was not worked, my lord, because of some dispute between the panchayat, my lord. Thereafter, in the judgment, my lord, it is very much clear, clarified by this honorable court that no, this petition have been engaged as self-employed mechanic. Therefore, pump driver, therefore, they're entitled to be work, my lord. If your lordship, I'll show all the documents.
No, again, the same question I am putting. What right do you have to continue? Is there any legal, constitutional, or any law laid down by Supreme Court?
They have decided that is their decision. In view of the government decision, my lord, we have been engaged.
Government is not law. You government had decided, now the government want you to go.
No, they do not want to descend. They have issued a circular in 2013 saying that the self-employed mechanic will operate. Prior to that, my lord, we have been already engaged. Our contention since then it will applicable, but not for us. Suppose we will lose the work, same work. The people, those who will come as a self-employed mechanic will operate. We are doing same job. There is no basic differences, my lord. Only we will lose the job, my lord.
Can you do the work of the mechanic?
Lordship,
what is the population of your village?
Yes.
And of your age, there must be so many people
no, I have
who must have been interested in this.
But I have been duly engaged at that time, my lord.
We are asking for that appointment which you are saying duly
Appointment
engaged.
order I have given annexed, my lord.
That is not the appointment order. You read it yourself.
Annex 3.
Yes, please read it.
And if your lordship
Please read it. Please read it.
Annex.
It is very confusing. That Annex 3 is very confusing. Please read it aloud.
In Odia it is written.
Yes.
ଆପଣଙ୍କୁ ଜଣାଇ ଦେଉଛି କି
ଆସ୍ତେ ଆପଣ ମାନଙ୍କ ଅବଗତି ନିମନ୍ତେ.
No, my friend is holding 55. The
Okay.
lordship looking at 44.
All right, 55 ପଢ଼ନ୍ତୁ. Sorry, ପଢ଼ନ୍ତୁ.
In all the cases, issue is same, your lordship.
Issue is nothing. Issue is zero. Issue is an interim order which you have obtained 11 years back. That's all.
If your lordship permit me, I'll produce certain documents, my lord, with the government.
No document.
Yes, we have documents, your lordship.
After 11 years, no document.
Yes, lordship. In other writ applications also we have annexed. In some writ applications not listed before lordship.
Are you appearing in 21644?
Yes.
We will decide one case.
Then I have to keep that brief, your lordship.
We will decide one case and
Yes,
accordingly we will decide other cases also.
They were engaged by the Gram Panchayat, not by any state machinery.
Read that.
That's page 11. Sri Bhagavan Malik, the present petitioner, Swabalambi Karigor Karjor Istofa Deva Samandhe. So he has been resigned, and this is a communication to him. Now he has challenged that I have been disengaged.
Now he is saying this is appointment.
No, it's not appointment, it's only.
He is saying this is appointmental. That is why I am saying it is confusing. ଏହା ଆପଣମାନଙ୍କ ଅବଗତି ନିମନ୍ତେ
ଜଣାଯାଉଛି ଶ୍ରୀ ଭଗବାନ ମଲ୍ଲିକ ଗ୍ରାମ ସଚେଞ୍ଚ ଓ ଶ୍ରୀ ଶ୍ରୀଧର ବେହେରା 10/11 ତାରିଖରେ ଯଥାକ୍ରମେ ଗ୍ରାମ ପଞ୍ଚାୟତ ଅଫିସର ଡେଲାଙ୍ଗ ଛତିଶଗଡ଼ ପାଣି ପମ୍ପ ହାଉସରେ ଡ୍ରାଇଭର ଭାବେ କାର୍ଯ୍ୟରେ ଯୋଗଦାନ କରିଅଛନ୍ତି। ଶ୍ରୀ ଭଗବାନ ମଲ୍ଲିକ 1/1993 ପର୍ଯ୍ୟନ୍ତ 2 ମାସ ପ୍ରାୟ ଗ୍ରାମ ପଞ୍ଚାୟତ ଅଧୀନରେ ଉଭୟ ପମ୍ପ ହାଉସ ଡ୍ରାଇଭର ଓ ସ୍ୱାବଲମ୍ବୀ କାରିଗର ଭାବେ କାର୍ଯ୍ୟ ତୁଲାଇଛନ୍ତି। 31/1/2010 ଅପରାହ୍ନରେ ସେ ସ୍ୱାବଲମ୍ବୀ କାରିଗର ଦାୟିତ୍ୱରୁ ଅବ୍ୟାହତି ନେଇଛନ୍ତି। And thereafter he has filed this writ application in 2013 claiming that I have been disengaged.
That is what he is saying, engagement order. I am confused that maybe I cannot understand Odia. This is a like on resigning, what to say, experience certificate has been given, that is work
Yes,
for
yes,
2
ma'am.
months. On basis of that, you must have asked for wages and then continued.
Yes.
Maybe let's let it come tomorrow. I'll come with all preparation, my lord, with some 24. Your lordship. Please to hand over the one judgment.
Yes.
Regards to the similar nature, my lord, similar case.
Yes,
Only
yes.
there. Just.
There is nothing.
Para 23.
In that case, your lordship, she was not work for a period because of there is dispute in Panchayat, Gram Panchayat. But a similar order was passed in favor of her. And she was also farm driver. Here is the farm driver. All the documents I have annexed there. That it was decided by the government itself that it was given to the Panchayat that immediately they have to engage the farm driver, because whenever it was transferred to the Gram Panchayat in 2006, there is a crisis, my lord, to maintain the farm houses. Prior to that, there is regular farm drivers, my lord, in the department, my lord. In absence of the large number of pump houses, my lord, these people are engaged as pump driver, my lord. Thereafter, it was decided, my lord, by the government, my lord, that since then only SCM will engage as pump driver, my lord. Prior to that, these people have already engaged, my lord. In nowhere it has been directed that earlier those who have been already engaged as pump driver, they have been disengaged or discontinued, or their service will. In that judgment, my lord, the court has been taken care of all this aspect, my lord. Documents I have produced. Therefore, I may permitted to produce all the documents in this case, my lord.
Mr. Mahapatra, is this decision in your favor or against you? Because it's exactly same facts. The engagement letter or whatever you're referring to, that is actually a letter of disengagement saying you have worked for 2 months. So
their case, in particular, that case,
that the same letter.
So everything is same.
There is no engagement order. So you have been disengaged by that Annex 3 which you are relying on.
That Santilata Malli for a period, my lord.
Don't forget about Santilata. You go to your Annex 3, which I am saying, please read out, please read out. It says you have abandoned your service on that date and you have worked for some few months or whatever.
Particular Bhagwan Malli case.
Yes, yes. Annex 3. Why don't you read it aloud? Because you said that is the engagement order, so I was confused. No, please read it. That is, on the other hand, the disengagement order after 2-3 months. Please read it aloud, because few words are not very clear. So if you read it aloud, everything will be very clear. If you are unable to read, Mr. Samantra will read it. Padle?
Shapala means that is self-employed mechanic, lordship. He resigned as self-employed mechanic and engaged as farm driver, lordship.
Anyway, read it.
ଗୋଷ୍ଠୀ ଉନ୍ନୟନ ଅଧିକାରୀ ଖଇରା ଶ୍ରୀ ଭଗବାନ ମଲ୍ଲିକ ଏହା ଦ୍ୱାରା ଆପଣମାନଙ୍କୁ ଅବନିର୍ଦ୍ଦିତ ଜଣାଇ ଦିଆଯାଉଛି କି ଯେ ଶ୍ରୀ ଭଗବାନ ମଲ୍ଲିକ ଗ୍ରାମ ସଚେଞ୍ଚ ଗ୍ରାମ and ଶ୍ରୀଧର ବେହେରା ଗ୍ରାମ ସଚେଞ୍ଚ 1/1/12/2009 ରିଖରେ ଯଥାକ୍ରମେ ସମ ଗ୍ରାମ ପଞ୍ଚାୟତ ଅଧୀନସ୍ଥ ଡାଲମା ଓ ପାଣି ପମ୍ପ ହାଉସର ଡ୍ରାଇଭର ଭାବେ ଏ କାର୍ଯ୍ୟରେ ଯୋଗଦାନ କରିଅଛନ୍ତି। ଶ୍ରୀ ଭଗବାନ ମଲ୍ଲିକ 1/2009 ନିକଟରୁ 31/1/2010 ପର୍ଯ୍ୟନ୍ତ 2 ମାସର ଗ୍ରାମ ପଞ୍ଚାୟତ ଅଧୀନରେ ଉଭୟ ପମ୍ପ ହାଉସ ଡ୍ରାଇଭର ଓ ସ୍ୱାବଲମ୍ବୀ କାରିଗର ଭାବେ କାର୍ଯ୍ୟ ତୁଲାଇଛନ୍ତି। ତା 31/1/2011 ଅପରାହ୍ନରେ ସେ ସ୍ୱାବଲମ୍ବୀ କାରିଗର ଦାୟିତ୍ୱରୁ ଅବ୍ୟାହତି ନେଇଛନ୍ତି। ପୁନଶ୍ଚ ଶ୍ରୀ ସୁରେନ୍ଦ୍ର ଦାସ ସଚେଞ୍ଚ ଗ୍ରାମ ପଞ୍ଚାୟତର ସ୍ୱାବଲମ୍ବୀ ତାରିଖରେ ଯୋଗଦାନ କରିଅଛନ୍ତି। So in this 2009 notification, he is not entitled to get it.
He has resigned from the self-employed mechanic, then working as farm driver. That is, therefore, in his place as self-employed mechanic, some other person engaged as self-employed mechanic. SCM is farm driver.
Both pump driver and SCM. You yourself said that the employment will be.
I have been resigned as a self-employed mechanic, SCM, Swavalambhi Karigara, because of I am engaged as farm driver dealership. That is the letter, my lord. Bhagwan Malik and Sridhar Behera.
This is the engagement letter. This is actually saying that he has resigned.
Resigned as self-employed mechanic. That is Swavalambhi Karigara. Lordship. ପାଣି ପମ୍ପ ହାଉସ ରେ ଡ୍ରାଇଭର ଭାବେ କାର୍ଯ୍ୟରେ ଯୋଗଦାନ କରିଅଛନ୍ତି। ଶ୍ରୀ ଭଗବାନ ମଲ୍ଲିକ
କଣ ରେ ଯୋଗଦାନ?
ପମ୍ପ ଡ୍ରାଇଭର ଭାବେ କାର୍ଯ୍ୟରେ ଯୋଗଦାନ କରିଅଛନ୍ତି। ଆଇ ଏମ୍ ରିଡିଂ ଆଉଟ୍ ଅଗେନ୍ ମାଇ ଲର୍ଡ। ଏହା ଆପଣଙ୍କ ଅବଗତି ନିମନ୍ତେ ଜଣାଉଛି କି ଶ୍ରୀ ଭଗବାନ ମଲ୍ଲିକ ଗ୍ରାମ ଡେଲାଙ୍ଗ ଓ ଶ୍ରୀଧର ବେହେରା ଗ୍ରାମ ମଛଦା ତା 1/12/2009 ରିଖରେ ଯଥାକ୍ରମେ ଗଗନଧୂଳି ଗ୍ରାମ ପଞ୍ଚାୟତ ଅଧୀନସ୍ଥ ଡାଲଙ୍ଗ ଓ ତୋଡ଼ିଗଡିଆ ପାଣି ପମ୍ପ ହାଉସର ଡ୍ରାଇଭର ଭାବେ କାର୍ଯ୍ୟରେ ଯୋଗଦାନ କରିଅଛନ୍ତି। ଶ୍ରୀ ଭଗବାନ ମଲ୍ଲିକ 1/9 ରିଖରୁ 31/1 ରିଖ ପର୍ଯ୍ୟନ୍ତ 2 ମାସ ପର୍ଯ୍ୟନ୍ତ ଗ୍ରାମ ପଞ୍ଚାୟତ ଉଭୟ ପମ୍ପ ହାଉସ ଓ ଡ୍ରାଇଭର ଓ ସ୍ୱାବଲମ୍ବୀ ଭାବେ କାର୍ଯ୍ୟ ତୁଲାଇଛନ୍ତି। 31/1/2001 ଅପରାହ୍ନରେ ସେ ସ୍ୱାବଲମ୍ବୀ ଦାୟିତ୍ୱରୁ ଅବ୍ୟାହତି ନେଇଛନ୍ତି। ସ୍ୱାବଲମ୍ବୀ means SCM ରୁ then he working as pump driver.
So suppose you are working today as pump driver, what right do you have to hold that same position tomorrow? Whether you were appointed on permanent basis, was there any recruitment process or something? Or is there any appointment letter that you are appointed till you die or attain the age of your superannuation?
All these categories, lordship, like contractual, sir.
It's a contractual.
Like similar to contractual lordship. Similar to, but there is no specific lordship asking me, my lord.
Therefore, we are putting this question.
Lordship, if your lordship keep it tomorrow.
No, not tomorrow. Today,
because it's a batch of cases.
Any one case you argue, we will decide the law.
Only certain documents I want.
No document. It is for 12th year. No question of any document. No further document. Sorry.
If the documents in other cases I have annexed because chronology, because it is decided.
Mr. Counsel, you had a right to file a writ petition. You filed. You as a counsel, you had a right to argue. You are arguing. And we have a right to decide. We will decide.
Lordship, only
we will, unless no question of unless. Sorry.
I beg to submit the lordship in comment letter as per decision of the government, circular of the government. These people have been engaged as pump driver, lordship. The question only, your lordship, because of these people are working as pump driver.
All right. So one, you have conceded to this point that you did not have any right to continue. All right. Legal right to continue. You will say.
Lordship,
your lordship is ashamed of the fact that an interim order was passed in 2013 with an observation that interim order shall continue till next date, and next date is today. 11 years after that interim order.
I beg to submit a lordship. It is the decision of the government, my lord, when in 2006, your lordship, after the social dhara, when it bring the rural drinking water
All right, we
system.
will see your pleadings and decide the cases.
Lordship, only prayer, lordship, with that.
This is 2:45.
With
Just
great-
a minute.
with
This
the
is 2:45.
With the humble request,
No
lordship.
question of humble request. You cannot improve your pleadings after 11 years.
No, I am
Right.
not.
This is 2:45. We give you time till 4:30 to argue. And we will not interfere.
Certain documents at present in this particular read, I have not annexed. I have to annex some read petitions. I think, lordship, therefore, in the government resolutions, your lordship, I want to bring certain government resolutions, your lordship. I want to bring a lordship.
Mr. Mahapatra, you file the writ application basing on certain documents. You have been granted interim order, whatever,
In
basing
certain
on that.
cases-
Thereafter, a counter affidavit has been filed in the year 2014. We are here after 10 years.
In certain cases, rejoined affidavit, I think.
But you have also given us a decision here where it is stated that it is open to him to apply for engagement, but no right. The decision which you have given us, decided by a learned single judge.
In that case, your lordship, with the due humble.
Here, yes, here,
My humble submission.
virtue of the order of
She
this
was
court.
for a period, she couldn't join because of some problem inside the panchayat, gram panchayat, my lord. Therefore, this honorable court directed that in case she applied for fresh engagement, my lord, the panchayat will take in view of the according to the law, my lord.
Here you are continuing on basis of the interim order of this court.
Your lordship,
Does that give you any right?
we are continuing, your
To
lordship.
her bad luck, she could not come in time. So you are similarly situated. She could not claim for wages because she had been.
No, she has claimed. She has claimed.
She has
Was
got.
it- Yes, she got. But
When also she was not engaged.
because of some period, my
All
lord.
right, we have
So
understood.
she was she
We have
was not
understood.
allowed by the Gram Panchayat, my lord. Everything on that. Therefore, on this honorable court has in that particular case, my lord, in Santilata Malik case, my lord, that because of she didn't work for quite some period, so it is therefore the direction given in that case, my lord.
All right.
My humble submission, my lord, in 2006, my lord, when the after social dhara, my lord, when the rural drinking water system introduced in the rural area, my lord, it is by the government, my lord, itself directed to engage persons deployed as farm driver, my lord. Though the persons engaged as farm driver, because of there is no requirement of the qualifications prescribed by the government at that time, my lord, to engage as these people in category, because they want to operate the pump houses, my lord, in rural areas, my lord. It was the intention of the government to facilitate the drinking water at least to the people, my lord. Therefore, in hill station areas, in certain different areas, therefore at that time, these people have been invited because earlier some people were engaged as self-employed mechanic. They resigned. In some cases, they have been fresh engaged by the RWSS and the Gram Panchayat, my lord. In certain cases, BDO has been approved them in different categories, my lord. They have been engaged, my lord. The pump driver, thereafter, thereafter they have been in 2011, your lordship, by direction of the Tribunal court, they were paid minimum wages. Thereafter, this disengagement process initiated, my lord. Thereafter, after filing of this application, the interim order, they have been got the interim order, my lord. By virtue of the interim order, it is admitted that they are continuing, my lord, in this service, my lord. They are discharging their duties. My humble submission, my prayer is, my lord, the government has not decided to disengage these particular persons. Government in 2011, my lord, clarified that the SCM, since then, they will engage as pump driver. In nowadays, there are new pump houses opening in village areas, and there, government has fixed the modality, SCM, self-employed mechanics. They will operate the pump houses. There is no basic differences. These particular persons, pump operators and the self-employed mechanics, my lord. My prayer, my lord, let the people to continue in their respective posts as per government decisions and resolutions, my lord. If your lordship permit me, I'll file the affidavit with that respect with certain documents, your lordship. Because all the documents in that application also. My humble request, your lordship, I know your lordship be kind enough to the workmen, my lord. At this stage, if these people will go, my lord, they'll be completely bread and butterless, my lord.
Yes, anything else? Or judgment is over.
Item number 34.
Contempt 634. Contempt is against the order dated when the non-implementation of the order dated 9/4/2015. The contempt was filed, but the opposite parties did not comply the order. But instead of that, they filed a review petition, which was not known to us. It is not.
Review petition is now known to you, no?
Yesterday, last week, who had for the orders of your lordship, a copy has been given to us.
Yes.
But there is no, my lord, the last order of that review petition is, as it is absent, it was on 3/7/2015, my lord. I'm just reading for your lordship's reference. When the matter was called out, we required the personal affidavit of the Land Additional Standing Counsel, who had given repeated statements before us that the state has denotified the area and is not interested to contest the matter. It was on such a statement that Sri A.K. Bose Land Counsel for the central government was directed to appear in the matter and have it say. We say no more at this stage. At the request of the Land Additional Government Advocate, the matter is passed over for the day. List it after 3 weeks. After that, it has not been listed.
No, it has been listed subsequently. 4/8/2015, then 23/11/2015. All the dates matter was listed.
But as the review petition, copy of the review petition was not given to us, we were ignorant of such dates.
One of the terms that no such transaction was made. On the basis of that, review has been filed.
Well,
That is supposed to file an affidavit, but the affidavit has not been filed.
but I have not, only last week, there is no such order for me. For the petitioner, there is no such order. Petition of the writ petition.
Yes.
I've given a copy to my learned senior. So my senior can notes. No, my senior can now notes.
My lord, the question is whether review petition is maintainable. Because as for the general principle, the error apparent on the face of the record, review petition is being filed. So what is the error apparent? Let the state council say, what is the error?
Yes, your question is that the land on which these trees situate admittedly belongs to the petitioner. He wanted to cut it. There was a notification by the central government to include those areas in a protected sanctuary. And in view of section 26, capital A of the Wildlife Protection Act 1972, the state, they have to notification will be made and they can make an application or objection before the state authorities that it should not come, whatever may be the reason like land acquisition, they have to make an objection. And that objection will be decided by the state government. So because it was notified, the state government could not issue, that is the authority could not issue the transit permit. That was our stand. Until that, the state government has not denotified that area from the purview of. No.
Permit.
Yes.
Should approach the Supreme Court.
Right.
Supreme Court set aside the order and remanded it to
Right.
the state. Thereafter, the matter was being heard.
Exactly. And we say that because of this,
That day, some submission was made, which is not based on the counter.
Oh, yes, that is why we stated in our affidavit that it was not stated, but somehow and concession.
The fact is, because
gone through the record, so what I understood from that, I am saying.
Well, that's because
What actually happened.
it is more than 16 years after the filing. I read. It is still standing there because they have not applied. No, not land. It is what? No, because finding the attitude of the opposite parties, the petitioner did not cut it. Although for cutting, no permission is necessary. But in the meantime, as it is understood that they have excluded the land of the petitioner, not petitioner, along with other villagers of that village, and they have excluded it from the sanctuary purview. But at the time of filing the writ petition, it was not there. Subsequently, it has been excluded. So the state government can actually say whether that has been excluded from the land or not. The petitioner has prayed that if
It was notified. At that time, they could not have granted.
they could not have granted. But my lord, at that time, the petitioner has also had applied that if my trees will not be allowed to be removed by me on the strength of transit permit. So my land may be acquired by the opposite parties and
That's all no,
and
it's
the
not
trees.
question of acquisition. No. All disputes can resolve if the state government, central government now can say what has happened to the application made by the state government under section 26 capital A. That will resolve all these issues. No.
So it can be stated by the state council.
I can also take instruction from the PCCF regarding 26A application because in all my grounds I have stated that draft notification was sent for approval by the central government because under the act only
There is some decision of this court that the TT permit application should be disposed of within this time. So we will dispose of this application after 20 years. How many years?
After
There is a decision of this court giving the timeline.
yes, no.
Yes,
If there is no dispute, but here the
no dispute. There is a question of writing dispute.
land was
given ordered by this honorable court. The transit permit should be allowed within 3 months.
That has been set aside by the Supreme Court.
No matter. After that, after the Supreme Court remitted the matter to this honorable court had directed this. Considering not cut
Allowed to cut.
to issue transit permit.
Modification.
To allow to issue transit permit. My lord?
That is, order is very, read that order.
My lord, I am ready.
Does it say grant TT permit? It says.
got if necessary with the assistance of police.
No.
Yes, cutting, only cutting, lords. Cutting with the assistance of police.
No, my lord.
Yes, please.
Then it is 9/4/2015. My lord, it is modified order, that is.
Yes.
This is an application for modification, clarification, order dated 11/2/2015, and for a direction to the opposite party number 3, because there was no mention regarding opposite.
No order for issue of TT permit.
No, madam. No order for regarding the authority who will issue the transit permit.
Please read the previous order. If there is
My
no
lord,
order for issue of TT permit.
there is no direction to any other
The
authority.
order for TT permit, the original order disposing.
My lord, I'm just reading it.
Not original, sorry. The second time it was
Nine,
disposed of. The first order directing for issue of TT permit, that has been set aside with the Supreme Court.
Yes, ma'am.
Yes.
That,
Then the second.
ma'am. The second order 11/2/2015. Here is a case where the petitioner, though planted teak trees on the land, he is unable to cut and removed the same. Initially, his land was brought within the purview of protected sanctuary, but later the government of Odisha denotified the area from the protected sanctuary. Therefore, the land on which teak trees have been planted is now a free land. Initially, when the writ petition was taken up, Land Additional Standing Council made a statement before the court that since the land have been denotified and proposal to that effect has already been made, he is not to contest the matter, as it relates to Union of India, who is to contest. On such statement, we directed the counsel for the central union government to appear before us. time was granted to the union to verify the position. And after some adjournments, the matter has been listed today. When the writ petition is taken up on behalf of Mr. A.K. Bose, Lawrence, Assistant Solicitor General, representing the Union of India, a statement was made by Mr. P.K. Das, advocate, that union government has got no objection.
Have you filed any reply to the review petition?
No, my lord, the review petition I just last week, and it has not been still.
But you will have to, because there are certain facts asserted in the review application.
My lord.
Those are very, those facts go to the core of the dispute.
My lord, the fact is whether at present that position is standing or not. That the state,
That is not the question. The question is as to whether when the order was passed, that order was passed based on correct set of facts or not. That is the question.
My lord, the present fact is that they have filed, then it comes within.
The order was passed under an impression that the area has been denotified.
My lord.
Is it not correct?
My lord.
That was the foundation of that
by
order.
this order. But
they say that is not correct.
My lord.
Factually incorrect.
Sir, my prayer is that whether that stand taken by them is at present standing or not, because
that is different aspect.
My lord, they let them obtain instruction.
No, you tell. You also.
How can I know that the government have notified or not? Because it is within the state government and government of India.
Yes, so, what is your stand?
No, our stand that's why I'm not saying I can take instruction from the authorities. Whether in the meantime state government, central government has given clearance.
Because you had already
submitted the proposal before the central government.
Much before that. That means 15 earlier to 15.
List has jointly requested this matter on these matters on 2 weeks to be taken up within first 5 cases. Stop. In the meanwhile, learned AGA shall be required to seek instructions as to whether what is that?
No, so the requisition made under section 26 capital A of the Wildlife Protection Act 1972 minutes.
You have met?
Requisition made on the basis of capital section 26 capital A.
Regards outcome of the requisition made by the state government under section 26 capital A of the Wildlife Protection Act to the central government.
Yes, sir.
Stop. Central government is a party.
No, but central government is not a.
Must have been party.
Because in the original writ application, they were not parties.
Original application, they must have been party because their stand was.
How were they called and how was the order passed?
Only on the basis of the
oral instruction.
Statement made by state government.
No, their counsel came and then made that they have no objection.
Order passed by this honorable court that Mr.
All right. But here you made them a party. Please see.
I will.
You have.
Yes, nurse. 124 original writ application. You are not party.
The Inspector General of Forest,
yes, nurse.
Wildlife Division is opposite party number 2 in the revision application.
Review application, nurse. Right.
Review application.
Yes, ma'am.
Have you served a copy?
Central government, nurse. No, I will serve a copy in course of the day on Mr. Party.
Is the addition of party there in your file?
Yes, nurse. OP number 2, nurse.
Yes.
OP number 2.
Yes. Because it is by hand, so that
yes.
way I will ask. The party on 12/5/15.
Item number 35.
I beg pardon to submit, my lord. I file an intervention petition, my lord. However, I file a judgment of Supreme Court, my lord. That may be seen. Only that may prayer.
We saw on last date, do you remember? I asked you a question
My lord,
about that B.Ed qualification. It is that case.
my lord.
B.Ed qualification is not necessary for appointment of primary school teacher. So that is what
Primary-
Supreme Court has decided.
No, primary school teacher was class 1 to 5. That is primary and that may be seen, my lord. That is my.
In fact, in your lordship, on 14/5, your lordship had directed the director to file an affidavit to assist the court. I am there before your lordship. You're supposed to file an affidavit. 14/5 order, your lordship may see that will clarify the position.
Fourteen five. 14/5, yes. Yes, whether the affidavit has been
Yes,
filed.
I have filed an affidavit on
I have not
2nd
received-
July. On 2nd July, I filed through e-filing, also submitted hard copy. What do they do? Any extra copy?
I have not received it.
They do.
A copy of the affidavit said to have been filed on behalf of the state of Odisha in compliance of.
It's there before us, not page mark, but it is there. Like he not. Yes, he has not got.
I'm serving in course of the day.
And counsel for the petitioner in course of the day.
Well,
Not petitioner.
yeah, amicus.
Amicus. Amicus.
Oh, sorry. Learned amicus theory in course of the day. This matter on 1B.
Item number 36.
I filed, in fact, on previous occasion, few dates back, I had filed a brief synopsis that is on your lordship's board. That will be important subsequently. As they keep on filing the affidavits, because it's a continuous process. The investigation they're carrying out, that's a continuous process which, for which your lordship has been directing them to file affidavits. That may be necessary.
You have filed?
There's a brief synopsis I had filed, previous to affidavits they had filed. Pursuant to that, I had filed a brief synopsis.
Scan. Scan. Thank you.
Item number 36.
Actually, the Thiba they do side.
$36.
Well done.
36.
So, no, which order?
Today in the morning, we asked to take other side.
Item 37.
So, yeah, date 15, sir.
Item 37, state has not filed counter. State has not filed counter.
Lordships were pleased to direct me to take instruction from the collector regarding status. Now obtain instruction that it is being not so constructed by the municipal corporation after obtaining clearance from this Kotak Development Authority. Now Lordship may issue notice where they are parties here. Lordship were not pleased to issue notice, only directed me. Now the notice has to go to them. Notice.
Yes, CMC and CDA have not been noticed.
Yes, Lordship.
It's no notice. CDS. Now requisites 1 week, 6 weeks. Yes.
Item 38.
It's item 38. Plus I pray for the next week. Reading has already been extended. So the final argument. So only I pray for next week, any day.
Why next week?
So any day, I'll prepare some dead chat, then I'll only next week, any day.
See, it is not easy for a case to be taken up.
Sir,
We'll see, let us see what is the.
Yes.
Question.
Lordship, you kindly see the last order, the order dated, order number 1, dated 13/9/2022. Because everything does, may I permit it to place me?
Yes, sir.
This matter is taken up through hybrid mode. Part Mr. M. Kanungal and a senior counsel appearing along with SKC Tripathi and counsel for the petitioner. The petitioner has filed this writ application to quash the order dated 9/6/2022 passed by opposite party number 3 in Means Appeal number 3/2022 under Annex 1 and to issue direction to opposite party number 4 to issue intimation to successful bidder being H1 bidder in respect of Jambira Sandquari Stage 3 in Moja, Borfera, Ranipal and Paramananda. Mr. M. Canonical and a senior counsel appearing along with Mr. K.C. Tripathi and a counsel for the petitioner contended that the Tahsildar Moroda issued a notification for grant of mining lease for minor mineral for the period of 5 years on 18/9/2021. And the last date of submission of bid was fixed to 25/10/2021. But due to Moirubhanj Pond, the last date was extended by the Tahsildar by letter dated 19/29/10/2021 and called upon the interested bidder to apply on 1/11/2021 between 10 AM to 4 PM. And as such, the tender boxes were to be opened on 2/11/2021 at 12 noon in the office chamber of Tahsildar Moroda. Pursuant to such extension of time, the petitioner applied for the same and quoted the price of rupees 1,025 per cubic meter, and the petitioner was declared as highest bidder. But instead of setting the source in his favor, the opposite parties settled the same in favor of opposite part number 5, who had quoted rupees 318 rupees per cubic meter, which is absolutely arbitrary and unreasonable exercise of power. As such, it is affected the state executor because of amalgamation of the revenue being, yes, my lords, that it was not been visible, my popular. The revenue being prime consideration is source should have been settled in a thrown way the price in favor of the opposite partner 5. It is contended that even though the petitioner preferred appeal under Rule 46 of OMMC Rule 2016, but the appellant authority has not applied its mind and also passed the order erroneously affirming the grounds taken by the Tahsildar by order number 9/6/2022 under Annex 1. Therefore, the petitioner has approached this court to the filing the present writ application. In that ground, Lordship, they issue notice to the opposite party. And the government has filed a copy. Lordship may kindly. Well, the date was fixed for the tender call notice. The Lordship annexure, first annexure, the 2, page 28. The last date of the submission of bid was fixed to 26/10/2021 at 11 AM. On that, the subsequent notification for the present sources is Jambura Sandwell. That was, Lordship, the 28 annexure 2. Lordship may kindly see the annexure 2, page 28. The application will entertain beyond the stipulated period after verification of the application in presence of the bidders of their authorized representative on 26/10/2021 at 11 AM in office of the undersigned successful bidder will be selected for grant of lease and incomplete application will be rejected. If lease will not be finalized on the first schedule date, then application can be accepted on 6/11/2021
and on 22/11/2021 till 4 p.m. in the second and third phase respectively, and on the next respective dates, that is the 8/11/2021 and 23/11/2022 11 a.m. So Lordship may kindly see the page 35 annexure 3. Because upon that day, the notification was issued dated 29/10/2021 that though the interested bidder who was not filed the application on that date, the date was extended for filing the submission of bid millers. This is to bring kind notice to public
So
that
what was the
auction-
last date?
Last date will be 26, the 26 millers.
25.
25, I'm sorry, Miller, 25 millers, 25.
26 in your presence.
Yes, Miller.
Yes.
That Miller, it was, that Miller, 25 is the due to Moirvan's bond, it was 25 millers. 25 Miller, that was reflected in the past Miller, she may kindly page 35. Yes, Miller. This is a bring kind notice to public auction process which was scheduled to be held on
So on 25.
25/10/2021
it was to be
yes,
filed.
Miller. Due to Moirvan's bond.
Just a minute, when did you file?
Miller, I have the due to date, I'm 30/10/2021 as per the notification. That is the 29/10/2021.
Who issued the notification?
That is the Tahsildar, Miller, Tahsildar. Who is the auction notice was issued, Miller? Same authority. Same authority.
All right.
So on that ground, Miller, Lordship may kindly that is the due to Lordship may permitted to read, Miller, that's the exact paragraph.
No, whether he had, Tahsildar had the jurisdiction to
Yeah,
extend the.
Tahsildar has issued the notification, Miller. The same authority has also issued this notification due to Moirvan's bond.
So on 25, you could not file.
Yes, Miller. Due to bond of Moirvan's bonds.
When was the notice issued?
Yes. Miller, let's see the 29/10/2020.
No, before 25.
Yes.
Or when was the notice issued?
Notice, Miller, the notice was issued on first
Original notice.
Miller?
Original notice.
Original notice is 18/9/2021, Miller.
18/9/2021 was the.
Auction of, Miller, the notification of grant of money.
Just a minute. You could have filed between 18/9/2021 to 25/10/2021.
Yes.
And you could not file it on 25/10/2020.
My lords.
So you were waiting for the last date to come.
No, Miller, not waiting, Miller. It says some documents are required, Miller. So I, Miller, collected the documents. So on that date, notification was issued, Miller. So notification, as per the notification, that is my crux of the point, Miller. The notification has itself issued by the same authority that what extension date. So many bidders have been applied, Miller, not me, Miller. So now, Miller.
No, whether any bidder who had submitted his bid after 25/10, whether anyone has been considered or.
That, Miller, that government can say, Miller, but otherwise, Miller, my instruction, Miller.
No, because you are taking this plea,
Miller.
then you will have to take this stand in your pleading that this person had submitted his bid after 25 and you had submitted also, and therefore he has been considered and your case has not been considered. Therefore, your case should also be considered. If that this is your case, then you may have some case.
Lordship, may kindly appreciate 1 minute. Because of this notification, Lordship, only for this notification, Lordship, that the same authority has been issued. That the concept, Lordship, may kindly consider my submission, Lord. There's only the same authority has been issued. The once notification has previous notification as the first notification has been issued for grant of 5 years lease below. The same authority has been issued. Those who are not filed the bid on 25/10/2021 due to Moirvan's bond called by the Moirvan BJP. Due to above circumstances, the auction process was hampered and some bidder were unable to submit their bidding application. The interested bidder can apply on 1/11/2021 between 10 a.m. to 4 p.m. to the competent authority in the office of Moroda Tahsil. The tender box will be open on 2/11/2021, 12 noon in the office of the Chamber of Tahsil and Moroda. Now, my lord, my also submission, my lord, I have quoted, my lord, the 1,025 rupees per cubic meter. The who is it, my lord, the successful bidder was quoted, my lord, 318 only. My lord, the difference is 700, my lord, 700 and odd, my lord, that was very different, my lord. And government will lose the revenue more than 10 crores, my lord, the entire 5 years.
And what was the date of Mayurbhanj Bandh?
Malas the 25.
Where
That
have
was
you said?
yes, 35 malas. The lordship may kindly turn to page 35 and extra 3 malas. That is the notification. The notice was issued by the Tahsildar Morada.
What?
Malas the for the extension of time that was reflected in that notice. It was reflected due to
Come to
Mayurbhanj.
the last page of the impugned order. Last but one.
Which order, I'm sorry, my lord.
Oh, last, not last for one, but the stand which was taken by Tahsildar
Tahsildar.
in the order. You see?
Malas?
Nothing, he was, just see the stand taken by Tahsildar. He says that he had not extended.
No, lordship, this is the notification.
What?
So this is the notification, Tahsildar's notification, my lord.
What is that?
Lordship, that is, my lord, page 35, lordship, kindly.
Read it.
Page 35 for a moment, my lord.
Yes.
Yes, my lord. That is the Tahsildar himself signed, my lord, and Tahsildar has issued notification.
What is that? Please read it.
Look, this is to bring kind notice to public that the auction process which was scheduled for past date, that is on 25/10/2021, was hampered due to the Mayurbhanj Bandh called by the Mayurbhanj BJP. Due to the above circumstances, the auction process was hampered and some bidders were unable to submit their bidding application. The interested bidders can apply on 1/11/2021 between 10 a.m. to 4 p.m. to the competent authority in the office of Moroda Tahsildar. The tender boxes will be open on 2/11/2021 at 12 noon in the office chamber of Tahsildar Moroda. That is the issue.
That's all.
No, let's
Next para is important.
Yes.
This is not read.
No, let's make the terms and conditions are public earlier by notice number 2683 dated 18/9/2021 will remain. I'm extremely sorry, my lord. I'm holding the second brief, my lord. I'm holding the second brief, my lord. I'm sorry, my lord. That WPC number 21503 of 2022. These terms and conditions as published earlier by notice number 2683 dated 18/9/2021 will remain stand in WPC website. This all the terms and conditions can be obtained from the Tahsildar office except holiday. But your lordship, in that way,
except
plus the can be obtained from this Tahsil office except holiday. That is written, my lord, in the office. Now, my lord, on basing upon this notification, I have applied, and lordship may kindly see they have also taken note in their, my lord, the application. Lordship may kindly see, my lord, page 38 annexure 5. All the bidder chart, my lord, they have prepared. Lordship first, my lord, lordship may kindly for a moment the page 38.
So that notice was by the auction notice, that was by whom? The Tahsildar?
Tahsildar.
That must have been approved by the collector.
Right. Prior to that, only he has taken the approval of the collector to auction the sand. No approval. No, my lord, that is not the reason.
My lord, in fact, the date is extended to 1/11/2021 for submission of the bid. What he did, my lord, he submitted the bid on 30/10/2021, enclosing a demand draft, which was issued by the bank on 30/10/2021. Because the other terms and conditions remain same, so he should have prepared that demand draft prior to the 25, my lord. He could not.
25 is the bulk.
My lord. My lord.
Waited the last moment.
My lord. My lord, that is one point. My lord, that is one point. Another point is that in view of Rule 27(4)(4) of my lord, he has submitted only one solvency certificate in both the sentence, so that solvency certificate is less than the what he offered.
That's different. On merit, if you have rejected,
My
that's
lord.
different.
My lord.
But on this, your notice is.
My lord, both the, my lord, we have two grounds, my lord.
No, no, you have a third ground also.
My
I
lord.
don't know how strong is that.
My lord.
It says that he did not have, Tahsildar did not have the jurisdiction to extend the date.
That ground also, appeal order.
My lord.
But your lordship, that
My lord.
that the appeal order, my appeal was dismissed on that ground, my lord. But the same Tahsildar has been issued, my lord. If the jurisdiction has not been there, how they have issued the such notification, my lord?
Exactly. Without jurisdiction, he has issued. That is what they are saying.
Tahsildar should have taken the permission from the collector.
My lord, it was also indicated in the my lord, the notice, my lord, the same say notification page 35. Copy enclosed to all, my lord. The copy submitted to the collector and district master Moirvanj for favor and kind information necessary action. Copy submitted to the sub collector. So that is my lordship. Lordship. Therefore, another date, my lord, I want, because lordship may kindly for a moment, my lord. So lordship, in this notification, as for this notification, my lord, the lordship may one thing lordship may consider, my lord. I have quoted the highest price, my lord, the 125 rupees. And my lord, who is the successful bidder was quoted, my lord, only 318 rupees. And after, my lord, they have also taken the consideration in their chart, my lord. Lordship may kindly for a moment, lordship may for a moment, my lord. Lordship, the page 38 for a moment. Annexure 5. Lordship got it. All the person they have included, including my name, my lord. Some first person, the present opposite party, my lord, the 5, that the Bikram Kishore Behra, that 318. Then Sukant Kumar Vidya, the 302. Then Amulya Kumar Bandra, the 531. Ajay Kumar Behra, 67. And Sumitra Rautra, that 223.50 rupees. Then the Prakash Kumar Das, 356. And the Dilip Kumar Sahu, that will be the 125. I have quoted the highest price. Yes. But they say that the same authority has issued the notification. That is there, my lord, the same authority has issued. And I have also.
Yes, on what basis do you say that he did not have, Tahsildar did not have the jurisdiction?
Because the view of the sub-collector, my lord, he has to take permission from the competent controlling authority, my lord. Controlling authority is collector.
Which rule? And what is the term?
One case somebody has completed the work.
Yes,
My
lordship.
lord.
We are operating lordship by
They are operating.
tender process, auction process. Lordship, since my letter, since lordship I am operating.
Agreement must have been.
Yes, lordship. Since lordship 2/2022. Lordship.
Max price he has given.
No, not equal. Lordship, kindly have a glance. Only my learned friend is relying part of the modification. Lordship, kindly have a glance to the page 35. There is a PPL, lordship, page 35, lordship.
page 35, first writ application, Lordship.
And second writ application I'm holding.
Yes,
That is
yes.
your writ application. You have appeared second writ
Okay,
application.
second writ application, Lordship, page 35. Lordship, got it?
Please, please.
Lordship, kindly have a glance to the NV notebook. That is the one of the conditions. If he is relying upon subsequent notification, there also there is a condition, Lordship. In NV, Lordship, they are given the just below the notice, Lordship. The float notice for participation left out bidders subject to approval of documents by the authority before 25/10/2021, Lordship. Subject to approval of the documents by the competent authority before 25/10/2021. So
26.
Lordship, this is my document annex.
Left out interested.
Lordship, left out interested bidders document. Lordship. Lordship.
Where you subject to.
Lordship, bidders to attach the document approved by the concerned authority. Lordship, page 35. Because my document is not legible, that's why I'm relying upon, Lordship.
You're reading something else.
No, what I have given in my death chart, Lordship, I'm reading. I'm reading the same documents, Lordship. Those, Lordship.
Which page?
35.
Page 35. Annexure 2, internal 30, Annexure 2, Lordship.
You first read the notice.
No, I'm reading the entire notice, Lordship.
Yes.
Lease notification Soirat such and such for 5 years. This is being to kind notice to public that the auction process, which was scheduled for first date, that is on 25/10/21, was hampered due to the Mayurbhanj Bandh called by the Mayurbhanj BJP. Due to the above circumstances, the auction process was hampered and some bidders were unable to submit their bidding application. The interested bidders can apply on 1/11/21 between 10 AM to 4 PM by to the competent authority in the office of Moroda Tahsil. The tender boxes will be opened on 2/11/21 at 12 noon in the office chamber of Tahsil of Moroda. The terms and conditions as published earlier by notice number such and such, Lordship, will remain stand in the website that they were given a reference. Bidders, besides this, all the terms and conditions can be obtained from the Tahsil office except holidays. Then, Lordship, Lordship, sorry.
They're required to be approved by the concerned authority.
Lordship, you have to prepare with all documents at the terms of the contract before the cut-off date. Those who have only the relaxation to the bidders, those who have not approached the Tahsil office, because the traditional form there, they have to drop the entire tender paper in the drop box, Lordship.
What is the meaning of approval?
Approval means, Lordship, they have to obtain the Lordship that solvent certificate from the Tahsil itself, Lordship. They have to obtain the bank draft from the competent authorities, Lordship. The documents must be before the cut-off date. Only they given the
See, there are two aspects.
Lordship.
The documents which are available up to 26.
Lordship.
Only such documents could be submitted.
Lordship. Grateful, Lordship.
Within that period.
That period.
But here the expression is the document approved by the concerned authority. What is the meaning of
Lordship, kindly come to
approved by the concerned authority?
27 rules, Lordship, 27 the rules, Lordship, kindly see. If Lordship, kindly 27 of the OMMC rules.
Here.
Lordship, kindly come to 27 Roman 4, Lordship, that is grant of 27 Roman 4, Lordship. 27/4 Roman 4, Lordship.
Yes.
A solvent certificate, bank guarantee, valid for a period of 18 months of the amount not less than
27/4.
Lordship. If Lordship, permit the entire 4 is relevant, I can the entire provision, Lordship. Subject to provisions of this rule, settlement of query leased in intending applicant may apply to the competent authority in a sealed cover by grant of query lease from such area or areas in Form M in triplicate accompanied by the following documents and particulars, namely. Then, Lordship, Roman 1, Lordship. treasury challenge showing deposit of 1,000 rupees non-refundable towards the application fees. Then an affidavit stating no mining due or payable under the act and rules made thereunder is outstanding against the applicant. Then proof of payment of earnest money equivalent 5% of the minimum amount additional charges specified in the notice and amount of royalty, both calculated on the basis of minimum guaranteed quantity for one whole year for the minimum guaranteed quantity of minor mineral to be extracted in 1 full year, and a solvency certificate or bank guarantee valid period of 18 months or for an amount not less than the amount additional charge offered and royalty payable for the minimum guaranteed quantity for the whole year, and list of immovable properties from the revenue authorities. Then Lordship, subject to the provisions of these rules, the co-release shall be granted in favor of the applicant who can quote the highest rate of the access, then other conditions, their Lordship. So this Lordship.
All
Lordship.
valid, I mean, have been issued by 25/10.
25/10 Lordship.
Apply.
Lordship, because only relaxes. Lordship, that is the condition of the subsequent notification, that they don't have Lordship. That's why the appellate authority reject on that ground, because you are not qualified, you have not given the solvent certificate, you have given that EMD after cut-off date. So on the date of application.
And your which document was ready before 26?
Lordship.
25.
Lordship, on the ground of reject by the appellate authority, my lord, that is the no ground, my lord.
No, forget, let us understand.
That is the 26, file correction, subject to correction, my lord. That is the
All right, that is
26, my lord, 2610.
Which document of your was ready before or on 26?
Was that application
3010,
was not annexed, my lord, but your lordship, that they both the file a counter affidavit.
Please try to
Lordship, that is, I
answer
bow
our
down,
question.
lordship.
Which document for the purpose of that bid was ready with you for filing, submitting?
Because lordship, they have stated the solvency certificate and all.
Any
Before
document,
25.
one document.
Yes,
you tell
lordship,
us.
that document I'll show, my lord, in additional affidavit I'll show, my lord, because
No
in
question of additional
present in that aspect, my lord, both the government as well as the private opposite party, they have filed counter affidavit. They have not filed any single line, even if the counter affidavit. I have suppressing dot. All, my lord, the 26 before 26, I have not having any documents. I having a documents, my lord. But though the documents are, that question has not been dealt with the appellate authority.
We allow you time, will impose cost. If any document is beyond 26, we will deposit heavy cost.
No,
Be careful.
lordship, so that guy.
Draft was prepared on 3010. Draft was prepared on 3010.
30, lords. The lordship may kindly allow me. I'll come back, my lord. The only for that instruction, I'll come back with your lordship. That
50,000.
No, lordship, may kindly similar. Lordship, my lord.
Mr. Patnaik, it is already there on record. I have read it.
Lordship, only I take
See,
instruction.
Mr. We are not saying that. Suppose your draft might be ready on 30th.
Yes.
We have put a question whether any
documents, right,
was there with you for the purpose of submission of the bid. All right.
That
if we find there was none, then we will impose cost because we have already spent a lot of time.
Lordship, my lord, only I take instruction, my lord. That is only
on behalf of
only because, my lord,
petitioner wants.
Lordship, I extremely sorry, my lord, but lordship,
Sorry.
Because,
and counsel for the petitioner state that only because there was band declared on 25/10/2021 at Mayurbhanj, he could not submit the bid. Full stop. Our attention has been drawn to the following in the notice dated 29/10/2011 bracketed annexure 3 to the writ petition bracketed WPC number 2150 of 2023. वो NB के बाद जो है ना quote करो page 55 पे. Stop. 1:11. Learned counsel seeks adjournment to file an additional affidavit to satisfy the court that the petitioner was all prepared to file to submit the bid. Submit the bid before 26/10/2021. The matter has been heard today for more than half an hour. As he is learned counsel for the petitioner is seeking adjournment on this ground, we indicate that if the petitioner fails to satisfy this court on the said point, the court will impose a cost of rupees 50,000.
Please see page 41 and 42. This is your own representation where you have stated you have not read your own brief. What to do? You have yourself stated I had not seen the earlier notice due to poor circulation.
Yes.
After I read the second notice, I've got all documents ready.
So only only that Lordship.
Okay, then this
No,
order stands.
no.
Only this order stands.
Lordship, I kindly, only that part, otherwise, I misunderstood the client.
Next.
So from the
Item 39. Item 39.
Red Bull.
Challenging the order factor on a single judge, Annex 7, kindly tell 95. Writ application or disposed of, dismissed. In the page 96, the operating part, my lord. 96, the operating part starts from 95, my lord.
Yes.
Therefore, this court is not inclined to entertain the writ petition so filed against the impugner after 6 years of passing the same, my lord.
Yes.
On that ground, writ application was dismissed, my lord, since I closed after 6 years. My case, my lord, before the single judge, my lord, I was appointed as an assistant teacher in the year 1980. While I was continuing, I passed B.Ed examination. In 2012, state government formulated resolution, a letter issued that those persons having B.Ed qualification subsequent to their promotion, they will get the benefit of B.Ed scale from the date they acquired the qualification. I approached the Learned Tribunal, State Administrative Tribunal in 2014 with a prayer to let my case be considered. Since I retired in 2012, my case be considered in view of the government letter. My Learned Tribunal disposed of in 2015, directing the government to consider the case of the petitioner. You consider the case of the petitioner in view of the letter issued by the state government for extension of the benefit. They did not comply the order of the Learned Tribunal. I filed a contempt application before the Learned Tribunal in 2016. That contempt application, they filed a show cause indicating therein that they have rejected the case of the petitioner by passing impugner on 12/12/2016. Accordingly, contempt application was dropped and giving liberty, you file a fresh application challenging that order. In 2017, I challenged that order, my lord, before tribunal, challenging the said that impugn order which was communicated through show cause, my lord. That was registered in 2017. In 2018, 19, tribunal was abolished, my lord. Thereafter, matter was transferred to this honorable court with a new number WPC OSC of 2017, my lord. My lord, kindly see that order, my lord, page 53. After transfer from the Learned Tribunal, after abolition, page 53, my lord.
Yes.
My lord, that is case number WPC OSC number 2023 of 2017. This was after transfer, my lord. This matter was taken about 12/8/21. After some argument was advanced by Learned Counsel for petitioner, he made a prayer that petitioner may be permitted to withdraw the petition with a liberty to file better application, better petition with a better particulars, my lord. After that, my lord, the present this writ application was filed page 16, my lord. Page 16. WPC number 8341 of 2020. On being granted liberty by this honorable court, I filed a writ application page 16, WPC 8341 2022, challenging the 2016 order which was communicated
and subsequently transferred to London Tribunal. That was dismissed by since indicating therein that since I approached the Honorable after 6 years. That is the matter. That is the only order matter, page 96. My lord, I retired, my lord, 31st March 2011. 25/11/2000, page 35. Government passed a circular in the after my superannuation. They said that those persons having BEd qualification while continuing.
Who is for the other side?
Statement.
Could not have been rejected.
But it is a fact, for moment, your lordship may see that he has earlier approached the tribunal in 2017. What was the prayer before the tribunal? The prayer before the tribunal in 2016, it is the admitted fact in 2016 his case was rejected. He did not challenge in 2017. While filing that original application before the State Administrative Tribunal, he has made a prayer that your lordship, under the above facts and circumstances, the applicant humbly prayed that this tribunal may be graciously plead to admit issue notice to the respondents, and after hearing both the parties, direct the respondent to frame necessary rules, if any, and create TGT scale of pay with effect from the date of BD to the applicant as soon as possible. This was in 2017. Prior, yes, my lord. In 2023, it is the admitted fact that he has written with a liberty to file a better application, because admitted fact 2016 order was not under challenge.
2016 order.
Well,
and the relief which he sought before the tribunal had no this thing connection.
Yes, connection that his prayer to grant him TGT scale was rejected in 2016.
Yes, so 2016 his claim was rejected. He went to the
Tribunal without challenging the same.
But what did he pray?
Yes, that I am reading his prayer, my lord. He did not challenge that rejection order. He simply
wanted
to frame a rule.
So whether that relief which he was seeking before the tribunal for framing new rules had any connection with the rejection of his claim in 2016?
Yes, because in 2016, when may I read that rejection, my lord?
Prayer. You would have got the relief.
In 2016, 17.
There he was asking 2017, the prayer he made for the tribunal.
Is my in.
Framing of you, not asking in public interest, it was in the own interest.
Man, that I'm what I am submitting before my lords.
Because the prayer was not properly framed.
Yes, and it is the admitted fact he has withdrawn. If your lordship that only on the ground of delay that has been dismissed, your lordship can remand it to the honorable single judge.
No, we will not remand. We will have your.
Then I let him place on.
Your affidavit.
We have filed an affidavit, my lord.
File?
Already filed and reply.
You have filed?
Yes, my lord. Let him place his case.
Yes, Mr. Why did you did not challenge the order?
My lord, page Annex 8, in 2014, I approached the London Tribunal for
No, forget that. In 2016, some order was passed. In 2016,
my lord,
you were aggrieved by that order.
My lord,
but you chose not to challenge that order. So you accepted that order.
My lord, 2016 order was communicated to me in contempt application in page 48. In contempt application, since order was of 2014 was not complied, in a show cause they communicated the order of the order impugned while filing a show cause. In 2000, my lord, that show cause was filed. My lord, page 51. In 2017, my lord. 17. Well, 29 March 17, contempt was dropped.
Challenge that order in 2017.
Well, I filed in 2017 OA, my lord.
Well, you did not challenge, you accepted that order.
Well, I filed the original application claiming the benefit. Since if my lord see the order impugned of 2016, they accepted that petitioner is eligible to get the benefit. They accepted. Proposal was submitted by the district education officer to the authority. But since there is no provision, according to the OP2, my lord, so no benefit can be extended. The impugned order, my lord. So I pray, since, my lord, the impugned order, my lord, can you see page 44, my lord.
So you also agree that 2016 order was rightly passed. So rules were required to be amended.
Rules are required, my lord.
This was your opinion while filing away that 2016 order was communicated to you in 2017. And you thought that yes, under the prevailing rules, the order has rightly been passed. Therefore, you sought for framing of the rules. Then you cannot challenge.
And that was, my lord, in 2018 with the liberty, my lord, I withdraw and subsequently on being liberty, I approach, my lord.
No, that liberty is limitless. Liberty is limitless. Sorry, sir.
Page 44, kindly see, my lord.
No.
The order of 2016, kindly see for last 2 lines, my lord.
No, right.
Para 4.
We have understood. You accepted 2016 order and thereafter when you attempted to challenge that here also, then you withdrew the application, then you again.
I approached 2017. But my lord, I pray for the release of the trend that scale of pay, but I didn't find to quash that order, my lord, 2016. But I pray for extension of that benefit since recommendation was made. That is why my lord, para 4 of page 44.
Oh, sorry. Sorry. Did you challenge the 2016 order in your writ petition?
My lord, after liberty was granted, my
after, not after.
After liberty.
Before.
My lord, is that 2017 matter was transferred to this honorable court, renumbered. That was withdrawn in 2021, my lord. So this original application, my lord, the order of the honorable court, my lord, page 53, my lord.
Nothing like that.
subsequent prayer was made for granting release of this benefit, extension of the benefit. So that matter was while pending was transferred.
Awesome.
Then graduates.
And I had the committee of be to be done before appropriate authority and for including the state administrative level. Right from 2004. And learn about passing of the order original application for After the cleaning of working the state has appeared that the commissioner had not specifically determined the state order whereby giving for grant of of pay indicate on the date of passing of examination was rejected. In his original application filed before the Tribunal, he has another call for relieving of the and to extend the benefit of TPSK law.
TGT,
That when things are rightly discussed, the on the ground of after reduce the materials on record and consider drivers submission made on behalf of the parties. We are of the view that there is no legal infirmity in the new order passed by the learned sector that the appellant had not questioned the corrections of the said order dated 22/6/2016, comma, in 2017 when he had made an application, made the original application before Orissa administration. For the first time, 2022, and for the first time in WPC number 841 of 2022, the appellant challenged the said order dated 22/6/2015 merely because the liberty was merely because liberty was granted by this court to withdraw the writ petition, that is WPC bracketed away number so and so, to file first the writ petition. Why it cannot be said that the petitioner had a press call of action to challenge the order dated 22/6/2016.
What is that other writ application number you have given in the certificate? One of 2020? WPC?
683.
Yes. Anyway, leave it because that is there in the certificate.
May I?
You are taking a contempt matter.
Specialist.
What happened?
I'm extremely apologize, my lord. I'm extremely sorry, my lord. I'm withdrawing my submission, my lord. That matter. Lordship, lordship, my lord, sir, only, my lord, lordship. Only, my lord, sir. I'm with an anxiety, my lord. I say something, my lord. So, lordship, may I extremely beg apologize.
Specialist.
Withdrawing, my lord.
Specialist item number 1.
Read petition also withdrawing, my lord. That will lordship may kindly, my lord. Lordship may kindly. Lordship otherwise, my lord.
Hello.
You want to withdraw the writ application?
My lord, my lord.
Give a memo.
That's your lordship.
Well, both the writ petitions.
Let's say. Red pull.
Yes. Please give your
I'll
memo.
give.
Otherwise, the old order will.
No,
stand.
my lord, sir. I'll give you. Withdrawal memo. And I'll get.
Specialist. Specialist item number 1.
Yeah.
Item number 2. Cancel. 9. Item number 2. Item number 3.
Non-compliance with the order dated 5/3/2012, my lord. Non-compliance with the order dated 5/3/2012. This petition, the contempt matter could not be taken as because an I was filed by the Union of India in the disposal writ petition, my lord. As because the writ petition was pending in high.
Why contempt petition as contempt writ petition? What is there in the writ petition?
There is a direction for issuance of identity card to BD worker, my lord. For issuance of identity card for BD worker, my lord. The petition of
Those
BD
BD workers, those
BD actually.
BD.
Forester.
So they wanted issuance of identity card. BD workers were preparing those BDs from their home. That was the prayer in the petition.
Yes.
And direction of their
The writ petition is pending.
writ petition are disposed and their contempt were filed. But prior to filing of the contempt, and I was filed. Interim application was filed with the Union of India.
Now it is over.
But why were you waiting? It has not been listed. I can understand it was listed and because of the IA it was adjourned. It has not been listed. The petition has been disposed of, but the IA has been filed and that is for appropriate order. For that he is saying that is why this was kept pending, but there is no order.
All right. Yes.
You're Mr. KCR Mahapatra.
Petition be given liberty to file afresh, my lord. As because till today the order has not been complied.
Item number 4. Item 4.
But has already become infectious.
Item number 5.
While the writ petition is pending is single bench assignment. Contempt I am not pressing. Let it be decided.
But yes, ma'am. I have no instruction. I have no instruction. That is why I am taking. Writ petition may be sent back to the single bench, my lord. I have no instruction. I have no instruction actually. Fine.
Both of us. Item number 6.
It's a suo motu PL, I mean contempt of. The contempt of Rajkumar Sharma, he was supposed to file. So may blame us. Item number 7.
Item 7 has become an infrastructure.
Item 7.
Item 7 has become an infrastructure. Item 7 has become an infrastructure. I mean, VC will order.
Item
7 has become an infrastructure. I mean, VC.
Item number 8.
Obligatory.
Item number 9.
No instruction, madam.
No, I've complied the order. I filed the so-called affidavit since long, I have order has been complied with.
Weekly list. Item number 40. Weekly list item 40.
Item 40, madam. This matter relating to that applicability of the PMR. PMR instead of CCA rules. Well, tomorrow it may, because this matter can be taken up tomorrow.
Forty-one.
My lord, in this writ application, a short question to be decided, my lord, whether the tahsildar
has the jurisdiction to decide an increased additional charge on the basis of an instruction which is not applicable to the petitioner, my lord. My lord, in the instant case, the petitioner was granted with a stone quarry lease, my lord, on the private land. It is not being auctioned. My lord, in the agreement portion at page 44, it is clearly mentioned that rent, royalty, and additional charge. Some fixed amount were fixed, my lord. As for those charges, I was paying all the dues, my lord. All on a sudden, in the year 2020, they come up with a notification, they come up with a demand notice which was issued without any so cause, my lord, by stating therein that you are liable to pay an increased additional charge on the basis of a notification that is issued by Revenue Disaster Management, my lord, by letter number 1410/2019. That has been annexed in the counter, my lord, which is clearly stating, and also the rule 39 of 5 of Odisha Minor Mineral Rules that is applicable for government organization. My lord, on that basis, yes, my lord, sub-rule 5 of Rule 39. My lord, found that rule, my lord? My lord, it is stated, it is stipulated therein, that is reservation of mines for government organization, my lord. Upon such reservation, prospective license come mining lease or a quarry lease, as the case may be, for the area so reserved shall be granted to the government organization in whose favor the reservation has been made, subject to such terms and conditions as may be decided by the government. My lord, 5 says that is the lessee to whom a lease has been granted under this rule shall pay to the governments all amounts payable by a lessee under these rules and such additional charges as may be decided by government from time to time. My lord, it is clearly stipulated in the rule and the instruction. Yes, my lord. They have by applying this rule during the subsistence of my lease period, my predicament is that, my lord, per cubic meter some amount has been fixed, and I was going on paying those amount, and now all on a sudden, without executing any agreement to that effect, how this rule is effective to me or applicable? Yes, my lord, kindly. Yes, my lord, kindly have a glance to page in my writ application, my lord. My lord, 47. Page 47. My lord, found that page 47, my lord. Here they have relied on the circular, my lord. Kindly have a glance. By the government R&DM department, wide letter dated yes, my lord, 47. They have relied on that the additional charges be calculated as per instruction issued by government R&DM department, wide letter number 1410/2019, my lord. Yes, my lord. My lord, that letter is affixed in their counter, my lord, at page 10. My lord, the subject matter is also very clear. This letter is 1410 2019, my lord, issued by R&D Management Department, my lord. My lord, the subject is fixation of additional charge or unit quantity of minor minerals in case of quarry lease granted to government organizations and
No, sir. I'm extremely sorry, Your Lordship. Mr. Mahanti was assigned with the file. So take it up tomorrow, he will address or you can dispose. Only that point I will intimate him whether this circular will be applicable or involve this. Yes, 39.5 whether it will be applicable, we can say privately query loss. Only that question was.
My lord, can I make a submission, my lord? In their counter, my lord, they are stating to this paragraph, my lord, they are stating they will be arguing. Yes. My lord, interim
42.
order is there. Interim order is there.
Item number 4.
Grateful.
For 42, in fact, will take it. My senior will argue for at least more than one because it's a final disposal matter. Also wanted to dispose of the main repetion without not going for the contempt. So, also fix a time and date so that my two.
Lord, here it's a renewal of a Khasma lease. Lord, this is the 9th visit to your Lordship, Lord. In this particular case, Khasma lease was originally granted in 9th visit to my Lord, 9th approach. This is the 9th approach, my Lord. Yes, exactly, my Lord. I want that. There ought not to be the 10th. Well, in fact, law is very clear and subject to what my learned friend from the other side says. Khasma lease partakes the nature and character of Sthitivan status. Sthitivan. Yes. Exactly. I fully endorse my lord's views, but it's absolutely correct. If the terms of the Khasma lease speaks in a particular tone, then it ought not to be rejected or declined by the authority on certain grounds which are not germane at all. That is the case in this matter. And there are a number of judgments of this honorable court with regard to the similar conditions in the lease. And that if the land, Khasma land, is required for a public purpose, then by giving a notice, they can cancel the lease or rescind the lease. It's a cancellation. It's a cancellation, Malad. Yes, cancellation. Malad, refusal happens when the lease expires. Thereafter, if the lessee does not want to go ahead with the lease again further, then it will be refused. But as per unless it's a perpetual lease, they are not bound to renew. That is the clause itself in the lease. Section 3 capital B Malad. After that came Khas on permanent lease basis. And that is the reason, my lord, the revisional authority. Otherwise, prior to that, I was approaching this honorable court. Then the revisional authority, my lord, rejects my application for renewal. And then, basing upon a resumption case, my renewal application was rejected and resumption order was passed. There was a resumption case against my vendor, who was the original Khasma lessee. There was no resumption case against me. Once this honorable court passes an order in writ application of 1992, disposed of in 1993, Malad, based upon that, the notice of the previous resumption case was issued to me. And the notice also spells out certain things, that the land is lying fallow, and that is the reason we are going to resume the land. And they never say it is for public purpose. And the judgments of this honorable court unequivocally states, my lord, that if a land is not used or used for a purpose other than for which the lease was granted, then it will be not cancelled. If it is not, it's lying fallow or not used for the purpose it is granted, then that will not give a handle to the state authorities to not cancel. That is judgment of this Honorable Court. And also based upon the Bihar and Orissa manual, revenue manual, before the cancellation of a lease of this nature, my lord, the prior approval has to be, permission has to be taken from the Board of Revenue. And here that is not obtained. Well, there are so many aspects involved in this case. But I want, as Rashid has rightly said, my lord, that ought not to be a 10th visit. I want the 9th visit. Let that be a curtain to this litigation.
So, fix any time or sub, because
Well, can it be 25th or 26th, my lord? And your lordship fix up at 2 o'clock, my lord? 25th, 2 o'clock, my lord. Obliged, your lordship.
45.
Right. Obliged. But interim order to continue.
43. Item number 43.
My lord, order passed by this honorable court has not yet been implemented, my lord, for which I have filed contempt petition. My lord may kindly from
My lord, 4 weeks. My lord, 4 weeks time I have already. Page 10.
Page 10. It starts from page 9. Order has, my lord, this my order is, the case is covered to the case of Malayananda Sethi versus State of Odisha. That is the judgment of the apex court. My case is covered to that. My lord may kindly see page 9, paragraph 4 of the order. Mr. So-and-so learned counsel for the petitioner contended that the case of the petitioner.
My lord.
Yes.
My lord, we have already filed complaint affidavit which was earlier rejected. Then I have filed complaint affidavit. Earlier by this honorable court rejected my affidavit, complaint affidavit. Then I have some time to file further affidavit, better affidavit to that effect. 4 weeks time.
Order dated 25/1/24. Order number 8. Dated
that order,
25 January.
In my complaints affidavit, order is page 16.
My lord may kindly see paragraph 3 of the order. Mr. So-and-so learned senior counsel appearing for OP that he wants to file further affidavit in compliance with the order of this court. Therefore, this court is not inclined to call OP number 2, Mr. So-and-so, senior superintendent who has filed the complaints affidavit dated so-and-so. And as such, the complaints affidavit so filed is hereby rejected. Giving an opportunity, the opposite parties.
My lord, 4 weeks time I will comply further.
Item 44.
Where is the lordship's kind permission? Just 2 matters after item 47 minutes. Those are all related to the batch of red petitions, about 20 or more minutes, pertaining to challenging state and central notifications under section 168 minutes. It's enhancing the outer limit for disposal of adjudication proceedings. Yes, almost counters have been filed and we have also responded. Barring counter, we are awaiting from Union of India and also GST Council. That's necessary party. Yes, they are yet to respond.
No. In some cases, my lord, GST Council and Union of India has already filed, my lord. I have filed because I have been instructed. So one cases your lordship taken, then other will be followed, my lord. So that is not an issue, my lord. Yes.
Correct, my lord. And
All
one
the
more
copies
problem,
may be exchanged, my lord.
one more problem.
Counter and
As per the practice and procedure, my lords, normally Advocate General defends the state. There is some difficulty also. Yes, my lords. Let them respond, my lords. Yes. Rightly, your lordship, let them.
Should we fix up another date, my lord, so that
copy has not been exchanged, my lord. The counter copy.
Lord, let it come, my lord. Next week, your lordship keep because this the affidavit which I have filed, my lord, so far as all these parties are.
the lordship may call it tomorrow.
Tomorrow I can start. Tomorrow I can start. My lord, day after tomorrow, let's.
Yes,
my
ma'am. Yes.
Day after tomorrow, please. Day after tomorrow.
Begin better next week. I think may bring for next week. I think you also fix it 2 p.m. so that matter can stop without 2 p.m. Next week, any day. Correct.
Your lordship. Your lordship call it tomorrow, then your lordship will fix up a date.
Tomorrow I am not.
Next week, yes.
Next.